Gonna have a final plea, like the final plea.
Yes, she had to like move it on the record and everything's off. I think she made the news. Yeah, okay. Can't remember, so we'll see. But,
Oh, and I have here final plea rights preserved.
okay.
Preserved.
Okay, let's get started. We have a trial calendar that starts on Monday. Today we'll call in the calendar to figure out which cases are resolving. Those that do not resolve, that are otherwise ready to go, will need to be here Monday morning for jury selection for one of those cases if we've got more than one that carries over from today. So let's figure out who's here and what the initial announcements are, and we will move on. Raheem Smith, he should be in custody. All right, and Mr. Melnick, is he in trial now, or he's going to?
Yes, Judge, he's in the County on the murder case in trial.
Okay,
I believe he sent an email.
I think he did.
I was sent and the state and all of the co-defendant's attorney for that case to notify that we believe it would be going into the next week as well.
okay, all right, so we'll need to check. Do you happen to know which judge?
I don't remember. I don't know if it's Judge Smith or a different judge. I don't think
Okay.
he mentioned it to me.
Okay, we'll figure it out. All right, Ms. Harrigan is here. Your lawyer is on her way. Ms. Cabrera will be here, so we'll wait till she gets here to talk about your case, okay? Shanika Francis?
She is also on the way. She's stuck in traffic. She'll be here in a second.
Okay, good. Kadir Bradford? He is here, and your lawyer, Mr. Luemba, is on Zoom. He is not 100% well and thought it would be better for him to be remote rather than here in person. Mr. Luemba, are you ready on Mr. Bradford's case, or what's your announcement?
Good morning, Judge. Thanks for allowing me to appear via Zoom. I'm kind of under the weather, but my announcement is ready when reached. I have gotten a new offer from the state that I got yesterday. Have not had the opportunity to relay that new offer to my client. I will speak with him today after court, let him know that new offer, but I am ready when reached. The new offer is significantly different than the first one, but I did get it yesterday, and I will let my client know about that when he's excused from court.
Got it. Actually, what we're going to do is when I finish calling the calendar, I'm going to ask Mr. Bradford to step out and give you a call so you all can have that conversation while he's still here. And then he'll come back in and we'll get a better sense of where we're trending, whether it's still likely to be a trial, and if I should have people come in on Monday, if we could do this trial without Mr. Smith, if Mr. Melnick's not available, all those kinds of things. So I'd ask you two to start that conversation that is triggered by the state's new offer.
Okay.
Great. But let's get a few other announcements. Ms. Brown-Melchor, did you get a new offer that you need to share with Ms. Francis?
I do not believe, I believe it's the same offer.
Okay,
Yes.
got it. So nothing's changed there. I should have asked you, I know your client's not here, but you're ready to go for next week?
Yes, we are ready, subject to scheduling, I guess, with other co-defendants attorneys.
Right, if we keep everyone together in the case.
Yes.
All right. And then there is Tyrone Patterson, the final defendant in the case. Mr. Patterson is here. All right, Ms. Rios.
All right, whatever.
Okay, understood. All right, we'll talk a little bit more, all of you, once Mr. Luemba and Mr. Bradford have had a chance to talk, after Ms. Francis gets here and after Ms. Cabrera gets here. Oh, you're here? Great. Okay, good. We still got to get Ms. Harrigan's lawyer here and have Mr. Luemba speak with Mr. Bradford. In fact, why don't you step out, Mr. Bradford? You can give Mr. Luemba a call now. He can just pop off the Zoom for now. You can give him a ring, okay? Omarian Lee. Hey, Mr. Lee, we're waiting on Ms. Cabrera. So when she gets here, we'll talk about your case. Mr. Roby, did we end up bringing him? Okay, he's here. But I think our situation is that the state is not ready. Okay, Ms. Wood, do you need, oh, Ms. Wood's not here. We'll wait till she gets here. Come back to that. Ashley Chambers. All right, we will see when Ms. Cabrera gets here, what she has to say about Ms. Chambers. Give me a quick second. And Ms. Chambers is co-defendants, several. We've got Elijah Thomas and Drew Powell is his lawyer.
So Judge, I did reach out. I've been trying to talk with Mr. Powell. I got a chance to speak with him. He said he has since retired and there is a new attorney for this case. However, that attorney has not filed an entry of appearance, so I could not have a conversation about the case, but I did speak with her and she said that she would be filing an entry.
He's retired, okay. Who is this new attorney?
Come 1 second.
Okay.
I'll put it down, I'll give it to you, Judge.
While you're looking, Ms. Rios, you represent Mr. Cotton, who's in custody. Any update on that case?
I just need to keep talking to him.
Okay, but you're ready?
Yes.
And then I'm going to do a bad job of pronouncing the name. Jenison? Yes. Good morning.
I spoke to her this morning.
She's in the back. She just raised her hand.
Okay.
There she is.
But we're pre-trial case.
Okay, got it. So your client and Mr. Cotton are ready. Ms. Chambers needs to show up. Well, we have a different situation there. And then Mr. Thomas has a new lawyer. Do we know yet who that is?
Still looking through my notes.
Okay.
I wrote it somewhere.
All right. All right, you guys can be seated. We'll figure out what's happening there. That gets us up to Ms. Ballard. We'll wait for Ms. Wood to get here to let us know what's going on with Ms. Ballard. Thomas Smith is in custody. Ms. Kim, that's your client?
Morning, Judge.
Morning.
Just got the acceptance for my client to enter, Pathways, Accountability Court, Drug Court. I just sent the attorney agreement form over to ADA Nix. They just literally sent it, so I guess we will.
Literally like 9:13 this morning.
Wow, just in time from drug court. Is it drug court? I'm not familiar with Pathways. Is it
Drug court.
a Fulton County Accountability Court? Okay.
Yeah.
So if I could have the opportunity to try to reach out to the victim, I did not let her know that it was a possibility to be resolved today.
Sure.
And if possibly I'm not able to get in touch with her, if we could reset this maybe to tomorrow or later this week for the plea instead of doing it today, if I'm not able to reach her.
Sure. Why don't you reach out to her? We've got all day. I don't know Ms. Kim's schedule, but you know, if the victim can plug in via Zoom or wants to be here in person, but that's at 2 or something, we could do that. Ms. Kim, when Mr. Smith and you and I talked about it before, he was a little on again, off again with the concept of accountability court. Is it your sense that he is more on again?
He's on again, Judge. I met with him and I explained very briefly how the program is, and it's actually very positive.
Good.
Yeah.
Okay, well, at a minimum, we would have him come out and say, here's what the plan is. We also could take the guilty part of the plea this morning, as in lock that in, but hold off on sentencing, which is not going to be a surprise to anyone. It would be get you into drug court. But insofar as victim wanted to be heard or be present for the sentencing piece, we could just do that piece tomorrow or early next week or whenever. But I'd like to know that there is resolution and get some of that locked in.
Yes, that sounds very great.
Great. So why don't you reach out to the victim, and Ms. Kim, we'll just sit tight and see what we learn from Ms. Nix.
Okay, thank you.
Thank you.
Judge, I have that information for the attorney.
Yes.
First name is Safisha, Safisha. Last name is Tembeka, Thembeka. I also have an email address and a number for her.
All right. And you've communicated with her.
I have,
She takes ownership of the case.
yes.
Okay. But she is new to the case. Okay.
I informed her about today and the potential of going to trial on Monday, and she,
Freaked out?
yeah.
Poor Miss Tembeka. Okay. Mr. Powell. But poor Mr. Thomas, he's sitting in jail. All right. We will see if we can get her on the Zoom this morning so that we can all talk, and maybe even get Mr. Thomas out here for part of that conversation. I think you had indicated that if this went to trial, it likely would be a Thomas Cotton trial and not a four-defendant trial. Did Ms. Chambers come here yet? Still no Ms. Chambers. Okay, Ms. Cabrera is going to be here shortly. I have confirmation of that. Would it be just a Cotton trial, or it would need to be a Thomas and Cotton trial? It's not efficient to sever those two.
Yes, Thomas and Cotton.
Okay, all right. Can you get
Sorry.
That's okay. Can you please send to Ms. Nelson the email address and phone number for Attorney Tembeka, so that Ms. Nelson can see if Ms. Tembeka can just hop on the Zoom this morning and we could get a sense of, I could be ready in a month. Oh my gosh, I only do trust and estates, or what the situation is. All right, thank you. So still no Ms. Ballard? Nope, okay. Thomas Smith, we just talked about. Ms. Nix is reaching out. Stephen Cook,
Judge, present.
he is, great.
Judge, at this point, at mere call from a week and a half ago, state had requested a little bit of mitigation evidence be provided in the form of evaluation.
Yes,
Mr. Cook has had an evaluation done 2 days ago. He got on, and when it's promptly, we're just waiting for the report. I renewed my request to move this to the end of May. Hopefully we'll have the report by then and get the schedule on.
okay.
Actually, free trial that this morning?
Yeah, why don't you guys talk some? Yes is the answer. Ms. Nix reminded me yesterday, we were having a little huddle about which case might go to trial, just talking procedure. And she reminded me, I think you told Mr. Mondelli, because he was working on this. So why don't you talk? And we'll see if there's something that can happen today. If not, then the hard stop would be the end of May calendar, because the report ought to be generated by then. If that's enough to move the needle for the state, it is. If it's not, then it's a less favorable plea or it's a trial. All right, great. So you guys talk. Let's regroup before anyone goes. So once you've had a chance to talk, just let me know. Michael Mack is here. All right. Ms. Rios, you had mentioned you were ready on that?
Yes.
Okay. Any reason for you or Ms. Willingham, for you and Ms. It's not a try. You are going to talk to her real quick. She's going to talk to you. If you don't resolve the case today, you need to be back here Monday, 9 a.m. Okay? And be prepared to be here for a few days. Trial isn't a 20-minute event. It would be Monday, we pick a jury, and it might be Tuesday, Wednesday, we're dealing with witnesses. Okay? All right. Ms. Rios, let me know if we need to talk about this case again today. Zoom is doing something weird. Ms. Nelson, are you able to hear us?
Kind of on and off, Judge.
Okay, it's popping on and off on the screen here. But as long as you can hear us now,
Yes.
great. Okay. 2-0, just got here. Ms. Ballard. Hey, how are you? Your lawyer is running a little late. Bad weather leads to bad traffic, but she will be here, and then we're going to talk about your case. Thanks. That gets us to Preston Cobb. Mr. Cobb is here, and I think that's a plea today. Okay, are you ready on that?
Yeah, I just have to send it to, let Mr. Davis know so he can hop on.
He's on.
Oh, okay.
And then Ms. Dublette should be in custody.
Yeah.
Is she here?
Yeah.
Okay, great. Is that, you're not sure?
Try, but I'll talk to her, but, just to confirm, but you can try.
You're ready?
Yes.
Okay. That's it. Anyone here didn't hear their names called? 14. Let's go back. That is Ms. Chambers. Hey, you're here. Ms. Cabrera is stuck in that same traffic as Ms. Wood. She's going to be here. She's got a bunch of clients here. So she will be here. Once she's here, we'll get an announcement from her about what's happening with your case. Thanks. All right.
And Judge, Nick and I spoke about Mr. Cook.
That was quick.
Yeah, it was a very good conversation. There's going to be a recommendation for virtual PPI this next game. Take towards a, we have to do a compliance state rather than put this on the next trial calendar. We have an agreement in principle in place to do that.
Okay. The way I typically do those, and I still call them PTI, there's nothing virtual about it. It's just not run through the DA's program. Is Ms. Nix is going to list the requirements. And if you're good to go with those, then she will get to me a proposed order that says you've got 6 months or whatever the needed time is to do A, B, C, D, E. If you don't, the case comes back and can be prosecuted. If you do, it'll be dismissed. And there's a pretty standard template they use. No one needs to come back to court for that unless there's something you think you need me to help navigate.
No, Judge, we're just your piece of mind give that matter of that question, Judge. So we're on board with the terms that Ms. Nix proposed. He's already, the evaluation was one of them, so it's already in process.
Okay.
And unless we need us to put something on the record, Judge.
No, I just need her back in the room to confirm that. So when she may be trying to talk to the victim in that other case. So let's just sit tight. When I see her, we'll pivot to that.
Thank you, Judge.
All right. Come. All right. Ms. Wood, good morning.
Hello, how are you?
I am well. Of your clients, let me tell you who we are worried about in terms of where are you. There was at least one, I feel like. No? Hold on.
Roby, you were gonna see if.
Wait, no, we're talking about, but we know where he is. But Ms. Ballard made it. Ms. Ballard wasn't here, but she is here now. So you should talk with her. And I think that's it because I think Roby is your other case. And so the question is whether you want me to engage with him on the announcement that we're going to bump it one calendar.
I will speak with that.
Okay, he's here. So to speak with him, if for some reason he's like, well, I'm unhappy, I want to be heard, you're welcome to bring him out. Otherwise, I'm going to give the state the one rollover. Ms. Cabrera,
Yes, Judge.
good morning.
Good morning.
You have several folks here. Ms. Harrigan is not here yet. And she showed up. Oh, no, Ms. Harrigan was here. Yeah, Ms. Harrigan is here. So you need to chat with her and then we're going to have a group discussion. Mr. Lee, Omarian Lee, he stepped out. So Omarian Lee is here. Ms. Chambers is now here. Yeah, got here a little late, but she's here, which is great. And that's it. So, yeah, those folks to.
The conversation happening about Harrigan?
Only that I was getting an announcement from, a few of the participants and we needed to get yours so that we could then have a group decision. Mr. Melnick is stuck in trial in DeKalb. And so it's possible if the case goes forward on Monday, it would have to be without Raheem Smith, if that makes sense. I don't know that it makes sense, but so far that's the one who is saying, I can't be ready because I'm stuck in court. Ms. Francis is ready through Ms. Brown-Melchor. Mr. Bradford is ready through Mr. Luemba, although there was a new offer, and so something may happen today. And then Mr. Patterson is ready through Ms. Rios. So we needed to hear from you. Is Ms. Harrigan a case that's going forward or is it resolving and is it ready?
She has an offer that I was emailed last night, so I need to share that with her.
Got it. You're in the position of Mr. Luemba. So he was speaking with his client. He's come back in. So if you would speak with Ms. Harrigan about that and see if that changes anything or what's cooking, let me know. Because we just need to make a plan for that big case. That'll free some people to leave. Then you can pivot to Mr. Lee and Ms. Chambers. Great.
You can answer that and then.
Yep. Then we'll handle the others as you see.
And I think Ms. Chambers, I think the co-defendants maybe headed to trial.
Yes, Thomas and Cotton, I've been told, will be tried and tried together, but Ms. Jennison and Ms. Chambers would be separated out. And I heard they might not even be going to trial, but that was a state forecast, not a,
That's correct.
okay.
I had given, I want to explain it to Ms. Chambers a little bit better. So she has a lightweight heads up on that.
Yeah.
But yes, that is correct.
Okay.
So if I can speak with her and then she can be released and not have to appear again before judge, that would be great.
Okay, let's start with Ms. Harrigan.
Yes.
And then we'll sort that one out. Then you can talk with Ms. Chambers and we'll figure out what we're doing there. Then you can talk to Mr. Lee.
Okay.
All right. You bet. Ms. Singleton, good morning. You are here for whom? Oh, okay. We are trying to get, Tembeka. Yeah, on, so we could bring him out and maybe they'd be meeting for, I don't know. Yeah. So we'll try to make that happen. For Mr. Thomas? No.
A motion was filed. I thought there was conversation at the last hearing that Mr. Powell actually showed up, that he was going to be filed again.
Okay. He did. You're saying it is in there? Okay.
So I did not know if that was, I know what type of calendar this is.
Yeah, no reason we couldn't talk about it if the state had notice and whatnot, but I don't know that it's on Ms. Smith's radar. Plus, right now, there's no lawyer of record. So all the more reason to connect with Ms. Tembeka. All right,
Thank you.
So,
Mr. Brown.
Mr. Brown said, is she excused or have to report on Monday?
No, if we could just hold on a little bit longer. We got two cases with a bunch of defendants. One of them is yours. I need to understand what's happening with the different parts, and then I can let people know. If the trial would only be Thomas and Cotton, then Ms. Junison doesn't need to come back on Monday, but we do need to figure out a little bit about what's next in her case. I don't want to lose track of that. So let's let Ms. Cabrera talk with Ms. Chambers, which is conversation number 2 for her, and then we'll figure out what we're doing. And in the meantime, we're going to try to track down Ms. Tembeka, your recently added colleague, the case.
Yes, sir. Thank you.
You bet. Ms. Smith, sorry to interrupt. If we're going to check with Judge Polk, that's where Mr. Melnick is in DeKalb. And if she said this trial's going to be over by tomorrow, we don't have changed lawyers or anything, so we could in theory have everyone for Monday. If Mr. Melnick is available, or is this something you could move forward with?
Yes.
Okay. All right. And Mr. Smith, was he the recipient of a new offer as well, or it's just Harrigan and Bradford?
Just Harrigan.
Just Harrigan?
Yes.
Mr. Luembo was saying there was a new offer.
It's the same offer, probably, but. I'm
Okay.
not sure.
Okay.
Yeah.
Can I approach for a second? I'm not related to this.
Sure.
You know, if the report came back on everything being evaluated, that's Mr.
Oh, yeah, Griggs. No, they're saying they need more time. I know.
Okay.
So, we may need to just get everyone on the phone because it seems to be stretching out.
We're ready.
Okay, well, it's not on this calendar. Oh.
You can let Ms. Harrigan.
Okay, you've spoken with her.
I did, and she maintains now with the state offer that she would like to move forward to the.
To trial. Okay. Then, now that Ms. Brown-Melchor is back as well, I am going to reach out to Judge Polk. We learned it's Judge Polk, to see what her forecast is for Mr. Melnick's availability. And if he would be available on Monday, and we'll get word to everyone, then this case would be what we'd try to do. We'd probably have to do it in another courtroom. It would be in this courthouse, but because it's 5 defendants, we might take over courtroom 1C. Don't get bad vibes. That was the YSL courtroom. It's going to be all right. This will not last that long. But I will try to find out from Judge Polk this morning what the expectation is, and then get word to you all, because that's a big lift for Ms. Smith to be ready on a 5 defendant case. But I've heard each of the attorneys say, defense attorneys, ready and will be here if this is what it's going to be. I just don't want to keep you on hold. If we know Mr. Melnick can't be here, then this isn't one we can do.
It's Thursday, isn't it?
Today is Thursday. What?
I'm just like, it's the end of the week.
It is,
So
right.
all these answers have to happen very soon.
Indeed, indeed. So we're gonna check with Judge Polk's folks right away.
And if it does go into next week, will the court want to address the severance issue now, or severing Mr. Melnick's client?
Oh, I think Ms. Smith has said, but you can let us know. I didn't get the sense this was a severable case. Absent, I mean, there could be a legal reason to sever. Oh my gosh, there's a Bruton issue or something. But short of that, the state hadn't expressed any interest. We don't want to try this twice. And there isn't a reason to pull someone out because they're so fundamentally situated differently. Is that still your read of the situation?
Yes.
Okay, so going forward with everyone but Raheem Smith would just mean that we'd have to have a second trial.
That's correct.
Okay, all right. So if Mr. Melnick is not, my email will be clear to all of you. I'm not going to say, well, let's see what's going to happen. It'll be on or off. If Judge Polk says, you know, it's possible we're going to spill over into Monday, then that's all I need to hear. But if she said, we're doing closing arguments this afternoon, then we will get rolling on Monday with this. But I will push word out to all the lawyers.
In the event they get pushed out, is the court open to maybe specially setting the case so we can get all attorneys on the same?
Yes, it would need to happen. It's too many lawyers. I'm kind of amazed that other than Mr. Melnick, people are saying, I'm not thrilled to have to go to trial on Monday, but I'll be there. But really the stars had aligned, but I think it's one where we need to, it's not a particularly old case, so special setting helps you with your calendars, but in truth, it doesn't, if there's an older case set somewhere, you got to go to that one. But it's a great idea.
Maybe have you future conversations about, just throwing that out there possibly. I know me and Keith have a murder case later on in the year, but we're pretty open in certain months and we wouldn't have to share all of that. Those
Okay.
cases that CBD.
Great. We'll figure that out. Full disclosure, if we don't specially set it next month, it's not my case anymore. You've heard, yeah. And Judge Ellerby's all for specialty setting. So it's not like, oh, we fall into this abyss and it will be 4 years. But I don't know that because of the World Cup, we would find a week, although we have a special, we get jurors on June 22. We're one of the 2 courts getting jurors on June 22. So that might be, we'll have to cast around and look as to what, but I want to be sure that week of June 22, it's a case that will go. And this might be one of those. So I'll check with everyone's schedule before we specially set something. That makes sense to specially set it when you've got a 2020 murder that week as well.
No, that makes sense.
Okay, so Ms. Harrigan, you are free to go. Stay in touch with your lawyer. Ms. Francis, you're free to go. Stay in touch with your lawyer. Mr. Bradford, you're free to go. Stay in touch with your lawyer. And Mr. Patterson is in custody? No, he's right here. All right, same thing, but stay in touch with your lawyer because we're going to find out about Mr. Smith's lawyer's availability. And I'm going to let your lawyers know. And the only way you're going to know if you have to be here on Monday is by checking in with your lawyer. Okay? Any questions about that case?
Judge, there is another co-defendant in this case, Demoya Francis, but that case has been on judicial hold after he failed to appear in arraignment sometime last year. So if there is going to be another trial for this case, it may be when that person is apprehended.
Meaning, well, we would go forward with these 5.
That's correct.
Because there's someone in the wind.
Yes.
If he reappears, you're saying, even if we resolve these other 5, there'll be this guy and something will need to happen.
Right.
Yeah. Okay. All right. Got it. So would you want to then sever Smith and just try Smith when Mr. Francis is taken into custody, or you'd prefer to go with the 5 that you've got?
I prefer to go with the 5 that I have.
Okay, me too. All right. Any other questions about that case?
Nothing from the fence, sir.
All right. We'll be in touch.
Thank you.
The prosecutor from that is tomorrow.
Okay. Finished as in everyone's rested, it's with the jury. All right. Interesting. Thank you. Little DeKalb intel. Is Ms. Nix out there? Could you just grab Ms. Nix? We can get Mr. Cook out of here. Hi.
I don't want to go to it's just that someone from Chambers called and asked me to jump on Zoom. So I just want to let the court know that I'm here for Elijah Thomas whenever, I believe I've missed.
Are you Ms. Tembeka?
I am, Judge Cook.
It is great to meet you. We were trying to find you. You need to jump on a Zoom for something else?
No, they were asking me to jump on Zoom for here.
Oh, but you're here in person. Great. Then let's talk. That's the other multi-defendant case that we've got rattling around here. So you have replaced Mr. Powell.
Yes.
Okay. How long have you been on the case?
I got the case.
20 minutes?
Basically, Judge, last month, and then even then, there was still some issues because when it was assigned, I went to appear for another case, and he appeared. And so I reached back out and said, what's going on?
Yeah.
You know, and he, at that time, he said, they told me, oh, he's retiring. And when I saw him, he was like, I've made no decision. So I said, okay, I said, well, I'm going to go. And then, I reached back out, and then maybe a couple weeks later, he said, I'm going to retire. So I said, okay, so.
Okay. Well, Mr. Thomas is on a trial calendar. I'm not gonna say you better be ready, but what I'd like to do is a couple things since you're here. One is to get you to file an entry of appearance, and we've got paperwork to that effect. So if you'd fill that out before you go. 2 is to bring Mr. Thomas out. Have you met him yet? So you may even want to go talk to him first, but I would like to let him know that I'm assuming you're not ready for trial. Okay, that's a fair statement. Which means we can't go forward. He is a co-defendant with Mr. Cotton. Mr. Cotton is very ready to go to trial, but I'm not going to sever them. And so we need to figure out how quickly you could get up to speed. But you need to look at the case file first. And I don't know that it's particularly complicated. It's serious charges, but it also could be a 20-minute incident that's all on video. Who knows? Is it that simple, Ms.
No.
Smith? It's not that simple. All right, so you're gonna need some time. And you need to start connecting with your client. But since you're here and he's here, I'd love to let him know what's going on. Do you want to talk to him first? Okay, then why don't we do that? I'll keep talking with a few of the lawyers while you meet with Mr. Thomas. And then once you've had enough time to talk with him, let's bring him out and we'll all talk. I'll let him know you're filing the entry, and then we can kind of recalibrate this so you've got a chance to digest discovery. No one had filed motions in it, which says to me they're probably not statements that need to be suppressed, et cetera, because they're full defendants and no one had. So I don't know, I'm not saying Mr. Powell wasn't thorough with the discovery, but I figure something would have bubbled up if it was a crazy bad police stop. Someone would have said, wait, they did this. But I want to give you a chance to look at discovery because you may see something that others didn't. And you certainly are entitled to file any kind of motions that we need to work through. I just want to keep that fairly compressed. Mr. Thomas hasn't been in jail for very long. Did something change with his status and that's why he's in?
He was actually 16 when he was arrested.
Oh, so he has been in custody for a long time. Just he's been in adult custody for not very long.
He was arrested on August the 6th, 2025.
Okay, he's just transitioned to adult. Okay, that because the number that I see is just the adult. He's been in a long time. Okay, so spend a minute with as much time as you need, and then pop back out, and we'll talk.
And Judge, they offered me an entry, but I filed a substitution account this morning and flow
Oh.
recovery, and it may not have been accepted yet, so that's the only reason why I haven't done it again.
If you've done the substitution of counsel, that's great. Now, if you're entering in discovery, that's good. Did Mr. Powell not give you discovery?
No, Judge, we're not in the same office, I've received nothing.
Okay, is it easy-ish, Ms. Smith, to send another evidence.com link out?
Yes.
Okay, so Ms. Smith will get that to you. She's got your email address. She shared your arrival on the scene. She said, hey, there's a new lawyer, Ms. Tembecker. So she'll get you discovery, and then probably what we'll do when your client's out here is just agree on a deadline for you to get back to me on, hey, I've had a chance just to skim discovery. Here's what I need. I need a month to get through discovery, another couple of weeks to file motions or whatever you think is reasonable so that we can get this back on course. Okay? All right. So you go chat with your client. Mr. Brown, your client is not resolving her case today.
That's correct.
Okay, then you and she are free to go.
We've got some paperwork we need, so.
Okay.
Move.
Great. Whenever you are ready to go, you guys, you don't need permission from me to get out of here.
Yes, sir. Thank you.
And Ms. Cabrera, same with Ms. Chambers, unless Ms. Chambers is resolving her case today.
She's not resolving that.
Okay, Ms. Chambers, you've got good contact information for Ms. Cabrera? Okay, you will get notice when you need to be back here. I don't know if the state's gonna try to call you as a witness in this case, but if that's gonna happen, that has to go through your lawyer because you're a named defendant in this case. And so there need to be some pretty serious conversations between the prosecutor and your lawyer about whether you're testifying or not. Okay, any questions? All right. Do you need Ms. Chambers to stick around?
No, I already spoke.
Okay.
Won't be on it.
Ms. Nix, Mr. Mondelli tells me that it's going to be pretrial intervention and that you shared with him the conditions that you expect Mr. Cook to have to complete. He said no issue, and I just wanted to close the loop that, in fact, that's your plan, that when you get a minute, you'll get to Ms. Nelson the order that would put this on judicial hold for X months while Mr. Cook does the things he needs to, one of which is to get the evaluation. And then the charges go away if he's done those things without getting in trouble during that window. Otherwise, we revive the case. That's the plan? Okay, done. So you'll be on that email chain and you'll know I'll sign the order once I get it. And if I'm all right with it, that'll be what happens. Mr. Cook, any questions? Okay, thanks.
Your Honor, I wasn't sure if the defendant provides the completion of the conditions to you or to this.
So what ought to happen is that Mr. Mondelli gets them to you. You say, good, and you reach out to Ms. Nelson to say, you know what, it hasn't even been 6 months. He's taking care of these things. Here's our motion to dismiss the case. and then we reopen it and close it.
Yes, sir.
Thank you, Judge.
You bet.
Judge, Monday, how many, is it just us on Monday or are there others calling on our days? I've already let Ms. Harrigan know.
Yeah, so you're only a maybe, but, because I heard what Mr. Abadi said, but, we're gonna just double check with Judge Polk anyway. But there are a couple other cases right now, Mr. Mack and Ms. Dublette, that are trials. So,
Ms. Harrigan on notice?
no, Dublette and your case.
Okay, I put Ms. Harrigan on notice that Monday might be a go.
Yeah,
And
good.
for her.
Well, you get an email from me today saying, let's make it happen. Okay? Or it's not happening. All right? Thanks.
Mr. Lee. Let's step down. Yes, sir. Real form, Mr. Lee.
Okay. I thought that Ms. Chambers was supposed to be a plea today.
It was a possible.
A possible plea. Okay. All right.
For the file. I just look at it. No, I actually don't. Good. The policy is working on it.
I don't know, what's not my computer.
At least it wasn't there, no,
No, mine's
email was
just
just working too.
my computer needs to update, so it's not really done.
It's really update.
Yeah, but it won't let me update it to get my IT because I need to get. It just has this red button on here that every time I try to update, it just doesn't. Yes. I'm thinking that's why the Odyssey is not working.
Oh, my Odyssey didn't work yesterday, it worked today.
It's not working again today. And it's just like, I don't know what's going on.
Something, they did something to Odyssey yesterday, so apparently.
Yeah.
Yeah, you're good. We're not bringing Roby out.
They're not working.
So you're welcome to have quiet time here, but go wherever you need to go. Sure.
Thanks, sir.
I mean, my IT person is like looking at my.
I'll have to go by to my city press.
He's fantastic, he's wonderful, he's amazing.
Yes, I do.
For his thing.
It was coming up. I usually have a copy of my file. Okay, so, the only way that we have to, okay, count 3. And library. What is that carrying to? So you have to.
Thank you. You know us.
Okay.
Do we take me now? Yeah, that would be great.
Oh,
Are we ready on,
Michael Mack,
okay, what are we doing?
negotiated plea.
Okay,
Does he have a code now?
I would prefer to go down with where you live before the meeting, take it over to them.
Yes. Oh, yeah. Before you go, I'm gonna give you a pen to start filling this out. And that way you can get started and we can get this done. Yeah, well, let's go through the plea. I'm gonna give you my pen and you can sit down.
Do they next?
Yeah, we can do that after and hand it in to them.
Okay.
It's always a gamble. These cases, she case cases are the worst. Because you just never know when the jury's not going to.
what's it saying on here?
Preferred camera's not working.
We turn it out when we get that preferred
Yeah,
camera
there's no
thing, we
guarantee.
just turned it off.
All right. Do it. We're agreeing for early termination after a year.
I
But if
mean,
you
it's
do early,
okay.
just reach out to me and I will file a motion and let him hear.
It is on there, but it's it's black, the camera's black, so it's not the preferred camera. I don't know how to change it here. Let me see. If I can switch the camera. Oop. You shut it off, okay. Is it coming back on? Great. Mr. Mack, will you adjust that screen a little bit? Just pull it so it's toward turn. Keep going. You're doing great. Good. Thank you. It should be ready? All right. Is it good? It's good. Fantastic. All right. All right. Ms. Rivers, are you ready? We're getting on the record with position 24 on the trial calendar. It's 25 SC 006 737, State versus Mack. Mr. Mack is here in court with his lawyer, Ms. Rios. Ms. Willingham represents the state. And Mr. Mack, it's my understanding that you are ready to move forward with a plea to a misdemeanor. Is that right? And maybe more than one misdemeanor, but it's misdemeanor pleas, not felony pleas. Is that right?
A felony plea.
Oh, it is a felony plea. Oh, I take it all back. Never mind. I misheard. You're ready to enter a plea in your case. Is that right? You need to answer out loud every question that's asked. Yes?
Yes, sir.
Okay, great. Then we're going to go forward with that. Ms. Rios is going to put you under oath in just a moment. Once you are, not Ms. Rios, Ms. Willingham is going to put you under oath. Once you're under oath, it's important that you answer all of Ms. Willingham's questions truthfully and completely. It's also important that you let me know if you have any questions. Will you do that?
Yes, sir.
Okay, Ms. Willingham?
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? You can put your hand down.
Yes.
All right, stop drinking water and make sure you answer out loud without your mouth full of water, okay?
Yes, sir. Yes, sir.
Now you can put your hand down. Please state your true, correct, and legal name.
Michael Mack.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
26, 11th grade.
Are you able to read, write, and understand the English language?
Yeah, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yeah, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yeah, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yeah, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding? Yes. Have you reviewed the indictment in this case? Yes. Do you waive formal reading of the indictment? Yes. Has your client been arrested on these charges? Yes. The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges? No. Mr. Mack, do you understand you are entering a guilty plea to the following offense? As to counts 1 and 2, those counts will be non-pros. As to count 3, battery, family violence, subsequent, there's a minimum of 1 year and a maximum of 5, and you would be entering a plea of guilty to that count only. The state would be recommending this is a negotiated plea for 3 years probation. You would be required to have no violent contact with the victim, complete families first, complete family violence intervention program, complete 60 hours of community service, have no weapons, seek and maintain gainful employment. And it is my understanding that you will also be asking for a 1-year bid date that the state would have no objection to. Is that what was explained to you?
Bid date is early termination date.
I'm
No,
sorry.
ma'am.
Okay. And are you aware the court does not have to accept that recommendation, and the court can sentence you to the maximum sentence, which is that 5 years, and can run the sentence consecutively or one after the other? In this case, it would just be that 1 count. Okay.
Yeah, ma'am.
Do you understand that if you do not accept the court's sentence, you may not withdraw your plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of this sentence?
Yeah, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yeah, ma'am.
Are you on probation or parole for anything, anywhere?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yeah, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yeah, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced pursuant to the First Offender Act?
Yeah, ma'am.
Do you further understand, because this is a family violence conviction, you are not allowed to possess a firearm, or you could be charged on the federal level?
Yeah, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yeah, ma'am.
Have you ever pled guilty or nolo, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yeah, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yeah, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yeah, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yeah, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a plea because you are in fact guilty?
On the effort, guilty on the effort.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yeah, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yeah, ma'am.
How do you plead to the charge of battery, family violence, subsequent conviction in indictment 25 SC 006737?
Guilty on the effort.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yeah, ma'am.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35 and must be completed within 30 days of today. Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yeah, ma'am. She said 3 years. 1 year.
Yeah, it's just the habeas. Yeah, that's fine. Your Honor, if this case were to proceed to trial, the state would expect to show that on October 8th, 2024, around 5:30 p.m., Officer Sharp responded to 496 Boulevard in response to a dispute with a weapon here in Fulton County. Upon arrival, officers met with the victim, Miss Michaela, Mekayla Pitts, who stated that around 5 p.m., her boyfriend instigated an argument with her inside Unit 506 after she returned home from getting her car fixed. Ms. Pitts stated that her boyfriend and the father of her children, Michael Mack, aggressively got in her face, so she pushed him. After Ms. Pitts pushed Mr. Mack, the two began to fight and tussle. Mr. Mack punched Ms. Pitts and pulled off her wig. At some point, Mr. Mack hit Ms. Pitts in the crown of her head with a black handgun. Mr. Mack proceeded to leave the apartment and leave the location. Ms. Pitts had a busted lip, a swollen knot on her forehead, and a small laceration on her hairline. She stated that this is not the first time Mr. Mack had been violent towards her, and the parties shared 2 children together, ages 5 and 2, who were both on the scene at the time of the incident. Ms. Pitts chose not to go to Grady at that time. Your Honor, I've spoken with Ms. Pitts, and that is in part why the state has chosen not to proceed forward as to counts 1 and 2. Although Ms. Pitts is comfortable moving forward to some extent, it is for the purpose, we do have the Families First program, and that is something that she believes the parties would be benefited by. However, she's not too thrilled to have to proceed forward in a trial, as this incident did happen some time ago, and she stated that they are doing better and that there have not been incidents, that they are able to have a healthy co-parenting situation for the most part. And with that, I don't know that her testimony now would be super beneficial as to the counts 1 and 2 with the firearm, because I'm not quite sure how Ms. Pitts will testify as to those counts. She does not deny that an incident occurred and that the defendant put his hands on her. Not quite sure she would support that a firearm was used.
Okay, she'd say I got beat up, but maybe not in the way it was described to the police.
Correct.
Back in October of
And
24.
for those reasons, the state has chosen to null cross counts 1 and 2, but do believe that even if we were to proceed to trial, we could still prove count 3. And for those reasons, this is the offer the state has made.
Okay. Thank you. Ms. Smith-Mann, do you have criminal history information for Mr. Mack?
Yes, Your Honor, I do. Mr. Mack is a multi-state offender with 4 cycles in Georgia, not including the case that's before you today, Your Honor. 1 cycle in St. Louis and 1 cycle in Tennessee. For Georgia, we have a 2020 driving without a valid license, a guilty verdict to a local ordinance. There is a 2020 battery, family violence, first offender, There was a probation for 24 months on that case.
I never
There
took
is a
no.
1023
I never took no.
sale, distribute, or possession of dangerous drugs. That was a guilty verdict in 6/2024. The St. Louis case for 7/23 for stealing is still an open case according to GCIC. Nothing further, Your Honor.
Thank you so much. Ms. Rios.
Yes,
Oh,
ma'am.
hold on, before we get to Ms. Rios. Did you have something else, Ms. Willingham?
Judge, I did review the defendant's criminal history, and we have the battery family violence, but we have it as a misdemeanor with no first offender used. So that is why, and I do know that that will change whether, or that was the integral part of our negotiations, was that first offender issue.
Okay.
He's saying he never used his
I
first
never
offender.
used.
No one said you did? Okay. Helpful to know. All right.
Yes, Your Honor. Mr. Mack is 26 years old. He currently works selling T-shirts. He's employed by a middle person who works for a company, and he basically outsources to Mr. Mack, and he sells T-shirts at different stadiums and arenas. He has 4 children, ages 7, 2 3-year-olds, and a 2-year-old. He currently lives with his mother, and he does share custody and gets the kids frequently. I've spoken to the victim in the case, and she said they have a good relationship. She has no concerns. She gave me a different story than she gave the state, that she was angry because there was some cheating going involved, and that's why she called the police. But she said, in the most part, they have a good relationship, and she just wants him to be out to support her kids. He's taking it out of Alfred because he's saying this did not happen. I will say, even on the video camera, she just say that she started the physical altercation. And so
he's not saying there wasn't a physical altercation. I mean, the officer said, we looked at her face and she has a busted lip and a knot on her forehead. So hopefully he's not saying nothing happened. It just may be, hey, she jumped on me and so we got into a fracas and she got hurt, I got hurt.
I mean, she's claiming that she got most of those injuries because when she was running after him, she fell. So
Okay.
I don't know what happened exactly. I guess we'll probably never know, but
We will not.
he is taking it under Alfred because he doesn't believe that it happened is the way that it's been was written in the police report.
Okay.
And we're just asking that you go along with the plea as negotiated with a 1-year termination date. If he gets all this taken care of, he's very eager to do the courses and get this taken care of so we can put this behind him.
Okay. Mr. Mack, you and Ms. Pitts are not together anymore.
We not together, but we good. Like,
Okay.
no problem.
I'm glad there are no problems. That's how it needs to be. You have 2 kids with Ms. Pitts?
Yes, sir.
So 2 of your kids live with her but visit you, or they live with you and visit her?
They live with her.
Okay, but you get them sometimes?
Yeah.
All right. And then you have 2 other kids. Do they live with you or they live with their mom or?
With their mom.
Mom. Okay, so just 2 moms total?
Yeah.
Okay. And you live with your mom?
Yeah.
Who else lives there?
My brother.
How old is he?
Finna graduate, 17.
Okay. So you and Ms. Pitts are good, you talk, and it's not a problem when you come to get your kids or she drops them off, that goes smoothly?
No, I go get my kid. Like,
You go get your kids. All right, and you are providing for them, and if she needs diapers or something, you help out with that?
yeah.
Okay. All right, do you have any questions about anything we discussed?
No.
How long have you sold T-shirts?
For about 2 years now.
Good money?
Yeah.
All right. Nothing on the edges, because you can't be selling T-shirts every day. You told me before, it's like, hey,
Yeah.
when there's like a football game, I'm out there selling the Falcons, and if they're playing the Saints, I'm selling, no one likes the Saints shirts. But games are once a week. What are you doing in between?
No, like it be concerts too. Like we go to concerts. We don't just go to like football games.
Yeah.
We do concerts too.
But there are enough events, whatever you're going to, concerts and games and whatnot, there are enough events.
Like events, really events, sell the events and shit.
Yep. But there are enough events that you make enough money to take care of your kids.
Yeah, to supply my kids, to help out.
Okay. All right. You take care of your mom too?
When I can. Like,
All right. Does she work?
Yeah, she work.
What does she do?
Security.
Okay. All right. Well, Mr. Mack, I find that there's a factual basis for your plea. I understand you're saying it didn't go down the way Ms. Pitts told the police, but if she told the jury what she told the police and the officers came in and said, hey, when we responded, she had this lip that was bleeding and this and that, a jury could believe her. They might not, but they could. And because they could, I'll accept your plea. I'm accepting it as an offered plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You may not be real enthusiastic about it, but you've made your own decision to go forward. Is that correct?
Yes, sir.
And knowing means you've understood the things we talked about. You agree with that?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And Mr. Mack, can someone in my office sign your name indicating your offered plea to count 3 of the indictment? The other 2 counts are being dismissed.
Yes, sir.
All right. First offender, you qualify for. It's mostly an opportunity if you are trying to go to school or get a different job. That's a whole lot easier because you don't have to check that box that says, are you a convicted felon? Or whether you check a box or not, if your employer is running your history, this doesn't show up as a conviction. That's the benefit. The risk of first offender is that if you and Ms. Pitts really aren't so good or something else is going on in your life and you get arrested again, in particular for putting your hands on someone, then we would have a hearing and I would have the ability to take away your first offender because you've already pled guilty. Even though it's an offered plea, it's a guilty plea. And I could resentence you without a trial. You get a hearing, but no trial, all the way up to the 5 years that you could get for family violence battery. Now, if you're pretty sure you're not going to be getting in trouble, first offender is a great deal. But if you're not so sure how you regulate your emotions when things get tricky with the ladies in your life or whatever's going on, first offender might be a little bit of a problem. How do you feel about that?
I feel good.
You feel good. All right. So you want to be sentenced as a first offender?
Yeah.
Okay, I'll do that. I will sentence you to count 3. I'll sentence you to 3 years probation on count 3 with several special conditions. The most important one is no violent contact with Ms. Pitts. Number 2, you need to complete the Families First program, and you need to enroll in that within the first 4 months of probation. You also need to complete the Family Violence Intervention program. It's a different program. It's a bunch of classes as well, and you need to get started with that within the first 4 months also. You're shaking your head. Why are you shaking your head?
I did.
Pardon me?
What did you do?
No class.
Which class?
What's the name? What he just said.
You already did a family violence intervention?
No, not now. I'm saying actually. Not the family violence.
Which one have you already done?
What he just said. You can keep going though.
Okay. So I was explaining that within the first 4 months of your probation, you need to enroll in the Family Violence Intervention program. If you've already done one of those and you can provide proof that you did it, probation can consider that. But if you've not done one before, it's not just anger management, it's a whole lot more than that, then you'll need to complete that program. You'll also need to complete 60 hours of community service, and you need to do that within the first 6 months of your probation. And I will set a behavioral incentive date at November 8th of 2028, 2027. So that's 18 months from now. If you have done everything that you need to do, then your probation can end early. But if you haven't, then you've got 3 years to take care of the things you need to take care of. You just need to get enrolled early on, and those community service hours need to be knocked out in the first 6 months. Ms. Rios, anything else on behalf of Mr. Mack?
No, Your Honor.
Ms. Willingham?
No, Your Honor.
Okay. Any questions, Mr. Mack?
No.
No? Okay. Ms. Simpson, do you live in Fulton County?
No, I live in 3239 Columbia Wood Drive, Decatur.
Decatur. So you are going to be supervised out of DeKalb County. Ms. Simpson is going to give you reporting instructions. She's going to meet with you. She needs to get a little info from you. She'll give you a piece of paper. Don't miss your first date with probation, because if you do, they just send me a warrant and you're off to a bad start.
Mm-hmm.
Anything else?
No.
Ms. Rios?
No, Your Honor. Thank you.
All right. Ms. Willingham?
No.
And Judge, I think we all thought we heard first offender. So the three of us all.
Oh.
It was first offense when I looked at the.
Yeah, she was saying that the family violence battery out of DeKalb or wherever it was first offense. She was,
Yes, that's it.
No.
We all thought first
Okay.
offender, so that's why we were all like, wait.
wait, he's already used it. Nope.
Yes, it was offense, Your Honor.
Right, that's what I heard. Thank you. Is Miss Tembecca still back there?
She's still.
Oh,
Judge, that concludes my duties.
can we get her if she's right outside? Thanks. Thank you.
Earlier, but I can continue. Sorry. I can go out there too. Okay.
Great. Hey, can we bring Mr. Thomas out real briefly? Okay, let's do that. Thank you.
We're gonna bring him to the podium.
You're ready to sit, but
Never mind.
I got you.
Yours one?
Mhm.
I go, what is wrong?
You go. Sure, in addition.
Okay. I'll just get it for a second.
You can take it. You want it?
I appreciate it.
Yeah, you're welcome.
hey, Mr. Thomas.
How you doing?
I'm all right. I just wanted to give you an update, although I think Ms. Tembecca has already done that. You've got a different lawyer now, and she is ready to go in terms of getting the discovery in your case and getting up to speed. But because she is new to the case, I'm going to have to postpone the trial. The trial was supposed to start on Monday. With Mr. Powell as your lawyer and a lawyer for Mr. Cotton, and you and Mr. Cotton were going to be going to trial. It's not fair to you or to your lawyer to say, my problem, she needs to be ready to go. So Ms. Tembecca will be getting discovery today or tomorrow from the prosecutor. She'll need to look over all that to get a sense of how strong or weak the state's case is. Are there things on video? Is there a confession or who knows what? I don't know much about the case. It's not my role quite yet to know about the case. But it will be Ms. Tembecca's role to become an expert in what the facts are and what they aren't. She's going to want to talk to you about her thoughts about the case, because that will inform whether she's going to encourage you that you may want to work this out. I'm making this all up, but you're caught on camera doing whatever happened versus you've got an alibi and you were in Tennessee when it happened. Then she'll be pressing the state to see if there is some other resolution than going to trial. But the goal in the end is to get you into court soon. You've been in custody for a long time. I know much of it was at a YDC, and now you're at the county jail. But you are entitled to a fairly rapid trial. I just need to give Ms. Tembecca a chance to get comfortable with what the evidence is in the case. And as soon as she is ready to go, then either we'll do that trial, you and Mr. Cotton will go to trial, or if what you decide is you want to sort it out and there is something you can negotiate with the state, I'm happy to take that plea. But we need to slow things down a little bit so Ms. Tembecca can get up to speed. I'm going to ask her to take a look at the discovery, just an initial pass through, and then get me an email and the prosecutor an email where she says, I need X weeks to be ready to go. Figure out if there are any motions I want to file, and then I'll be good to go. And that'll let me know this is when I can bring you, Mr. Thomas, back for a final discussion about, are we working the case out or is it going to be a trial? And if it's a trial, then we'll get you and Mr. Cotton in here, okay? I just want to explain that because the plan was to get going on Monday, but that wouldn't be fair to you, like I said, because you want a lawyer who knows this case inside and out, and Ms. Tembeka just hasn't had a chance to do that yet. Any questions? Okay. Ms. Tembeka, anything else on behalf of Mr. Thomas?
Judge, it's been brought to my attention that previous counsel filed a bond motion and that there was mention somewhere that today the court might consider bond. I would ask the court for just a few moments and to see if the court may be willing to just do a very brief bond hearing today if the court's, I don't know if it's on your calendar for today.
It's not. I'm flexible, but what we bump up against is whether the state has had an opportunity to contact the named victims in the indictment. And if they haven't, because they weren't thinking today would be a bond hearing, then my response would be, let's not wait weeks for you to learn about discovery, but let's give the state an opportunity to notify the victim so they can be present or give a statement to the victim witness advocate. And so next week or something, we could do the bond hearing. So tell me where you are, Ms. Smith.
Yes, Judge, I've had a chance to speak with the victim about how she feels about regarding all of the defendants. So the state is okay with moving forward with the bond hearing.
Okay, then really, Ms. Tembeka, I'll defer to you. If you want a little more time because one of the things I'm going to ask Ms. Smith is to say, well, tell me, there are 4 defendants in this case. And if the state believes the facts are that Mr. Thomas was way out on the periphery and he was a lookout and he was telling everyone this is a bad idea, you may want to know a little bit more about the case. So you could say, we're not going to dive deep into the facts, but my understanding, Judge, is that Mr. Thomas was less involved than if Ms. Smith is saying, hey, there was only one guy with a gun and everyone is saying it was Mr. Thomas. That is a different posture for bond than everyone's agreeing he was the lookout. So if you want to go forward today, we can. If you want a couple days to read like the initial police report, et cetera, then we could do a bond hearing soon. It's easy enough, consistent with your schedule, to get Mr. Thomas brought over here.
Sure, and I appreciate that, Judge. And quite frankly, we've had a similar conversation in the back. And I understand, for Mr. Thomas, I think he appreciates that preparation, is a better course. However, I think the opportunity for the chance to be heard on bond, it kind of outweighs the risk for him. What I would ask the court for is just a few minutes, just so that I can take a quick look at something in Odyssey.
Sure.
Okay.
So, Mr. Thomas, we're going to bring you back out here later this morning to talk about bond.
Yes, sir.
And we'll see what happens with that. In the meantime, all these other things I said apply. So even if in the end I say, I'm not inclined to set bond, Ms. Tembeka will be getting discovery. She'll be immersing herself in it, and then she'll be connecting with you to say, hey, let's figure out the way we want to move forward. Here are my thoughts. And she may want to share some of that discovery with you. If it's digital discovery, it's a little more complicated, but she can get an order from me that lets her bring a laptop into the jail so she can show you video and say, hey, here's why I'm recommending we do X or Y, because I might look like you on the video or whatever the evidence is. Okay?
Yes, sir.
All right, so we will reconvene in a little bit this morning to talk about bond.
Thank you, Judge.
Sure. In the interim, what, Ms. Nix, did you learn from the victim, if anything, in the Smith case?
Did you left a voicemail for her? Not able to reach her.
Okay. So, Ms. Kim, rather than keep you on any longer, my thought is we bring Mr. Smith out and I just get confirmation from him that he's good to go with drug court, and then we set this down for the plea sometime soon. Does that work for you?
That works, Judge. Thank you.
Does that work for you, Ms. Nix? Okay. All right. Then if we could bring Mr. Smith out, please. Thomas. It's a good question. I forgot we had another Smith.
Okay. Right.
Everything all right? Oh, I know they don't have anyone next door. Hey, Mr. Smith.
Hello, sir.
Good to see you again. Ms. Kim is on. Let me make her more visible for you. There you go. There's Ms. Kim on the screen. And she and I and the prosecutor, Ms. Nix, have been talking a little bit about your case. Ms. Kim shared with me the good news that you were accepted into drug court. When you and I spoke last time, you were warming to the idea of accountability courts. You had had some other ideas for treatment that would benefit you. And I had shared with you my thoughts that the drug court program is pretty comprehensive and supportive. And you've been accepted into it. We're not going to take your plea today. The state needs an opportunity to contact the person who's listed as the victim in your case, so that person can be present. Is it a he or a she? If she wants to be either on Zoom or here. So we're going to line up your plea for probably early next week to do that and then get you into drug court. Do you have any questions about that?
I was just kind of curious, if my plea is accepted, what would be sort of the next step towards me getting out of jail? How does that work?
So I think, let me ask Ms. Nix as the prosecutor, but I think the state's recommendation would be to release Mr. Smith to drug court, not to serve more time and then only later go to drug court. Is that a fair assessment?
Yes, that's fair.
So assuming I accept the plea, then you would get into drug court assuming your medical records check out, the next available Tuesday. They do intake every Tuesday. Okay. So I'm making this up. We do the plea next Wednesday. It goes through, I accept it. What I would do is sentence you effectively to time served. It's going to sound different than that. I don't say those words. In the sentencing order that I sign, release to drug court, and they will either come get you that next Tuesday or they'll need to get your medical record. So you'll need to sign a release if you haven't already, so they can make sure it's safe for you to be in drug court. But assuming everything checks out, then it would be that Tuesday or the following Tuesday. Will you need housing initially, or will you have a safe place to stay?
Yeah, I need some place to stay initially.
Okay, that will not slow things down. Drug court is able to provide supportive housing for at least 90 days after you get out. So that'll just be part of the package of services you receive. The key part is going to be getting those medical records. Next step is to figure out when we can get you back here to take that plea. And then, assuming the plea goes smoothly, we'll just figure out which Tuesday it is that you would start. So you're not going into the Department of Corrections, and you'll only stay at the county jail long enough to get to the Tuesday that is your orientation day. You would be picked up by drug court personnel. When you're done with orientation, you would go home that evening, and home would be the supportive housing that the drug court personnel find for you. Does that answer your question?
Yes, sir.
Anything else?
No, I think that's it.
All right, Ms. Kim, anything else on behalf of Mr. Smith?
Judge, if I could just relay a quick message to him, which is good news for him in a way. I did speak to Ms. Ward. I think all the paperwork is in. And if you, because she understands that you're in custody, it's going to take a little bit of time to get on your feet. So if you can't find housing within the first 90 days, they will extend another 90 days. So you don't feel desperate to, because right now with rental prices, it's going to be a challenge.
Great, go Ms. Ward. So this sounds like housing will be available even longer while you are getting situated. Part of drug court is an expectation that you'll be employed when you get to what's called phase 2. The classes shift to the evenings, and assuming there isn't some disability that prevents you from working, they help you with temp jobs and things like that. But there'll be an expectation that you're working, which will help solve the problem of, well, wait, how do I pay rent? Okay. All right, I will see you soon for the plea, and we'll figure out when drug court would start.
All right, thank you.
Ms. Nix, anything else? Okay, thanks, everyone.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you.
And that is my last case, I believe, also be excused.
Yes, ma'am.
See?
Ms. Rios, you got anything we can do while?
On, Mr. Davis to take his name, will be ready soon.
Okay, yeah, he was on, we probably took too long. How about you, Ms. Wood? Do you have anything we can do?
I will drive and Ms. Smith and I approached very briefly about it. I just have a quick question.
You may.
Yeah.
Go this way.
So, yeah. I know it's like 2 years freshman.
Who are we talking about? Okay.
I'm all making injuries. So, do I have to tell you that? I didn't really understand.
No, I don't think one ever. Because I don't want to.
I know.
But we recently had to Brian Steele and McGillicuddy, this big hot mess they had where it was, you gave us an offer and we took it back, and it was a Dunaway case, and Dunaway had to recuse, and there was gonna be a witness. The whole, is it a no-law thing or not? But it was the same thing, it was civil liability. That's what he said. So it was his was, every leg I could get was first offender, Nolo Alford. I'm not admitting to it, I didn't do it, and I want first offender. So there's nothing illegal about it. The state didn't oppose it in that case, outsourced, partly depends what the state has to say. And Ms. Ballard, I was looking at the letters, if this was a one-off thing, a little can make sense. Especially if there's a civil piece to it.
I don't know.
And here, with the one with Steele, there was that some sort of family of the victims, and we're not gonna, but they're clearly at each other's throats. They've already, they're trying to get this guy's probation revoked already because he and his mom posted about it when he was young, saying, I'm free at last, I'm free at last. They weren't supposed to do it, so it was stupid on their part. This doesn't seem like that kind of situation.
I've never done one, so I didn't know if I needed to when we do the how you do guilty or not guilty part.
Yeah.
She was saying one.
She's pleading no one.
Okay, cool.
Yeah.
That's all.
Do you have an issue with that?
No, I don't have anything further, especially than my college being about no law.
I'll manage it, okay.
Okay, cool.
Yeah.
Thank you. Yeah, I will be requesting first offender.
Yeah, okay.
So,
All
thank
right.
you.
Don't make it happen.
Yeah, I know better. Thank you.
Is that something we can do now?
Yes, you're ready.
Stand right here and just speak very clearly.
Ms. Cabrera, are you ready on Mr. Lee when we finish Ms. Ballard? Okay. Okay. Let me know when you're ready.
I am ready, Judge.
Okay. We're getting on the record with position 20. It's 25 SC 006282, State versus Ballard. Ms. Ballard is here with Ms. Wood, her lawyer, and Ms. Smith is here for the state. Good morning, Ms. Ballard.
Good morning.
How are you doing?
I'm okay. How are you?
I'm all right. You ready to go forward?
Yes.
Ms. Wood shared with me that you're prepared to enter a plea. There are going to be some conditions to it, but we'll get through all that. So if you are ready, then Ms. Smith is going to put you under oath and then ask you questions about your case and your rights. You need to answer all her questions truthfully. And you need to let me know if at any point you're confused by what we're talking about or things aren't going the way you thought they were going to be going, so we can address that. Will you do that?
Okay.
Okay. Ms. Smith?
Ms. Ballard, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Demoya Ballard.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
22, 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait.
Ms. Ballard, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Can you repeat that for me?
Yes. Do you understand that since this is a non-negotiated plea, that the court can impose any sentence authorized by law, including a sentence higher than what I'm recommending, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on parole or probation, that your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained what the First Offender Act is to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on your first offender probation, that your first offender status could be revoked, you could be adjudicated guilty, and you can be resentenced up to the maximum for the charge in this indictment?
Oh, yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
What was it?
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Oh, yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
You said, do I understand that?
Do you understand that
yes,
these are the
ma'am.
rights you're waiving by entering this guilty plea?
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this plea?
I am.
Ms. Ballard, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 006282, how do you plead to count 1, aggravated assault, and count 2, aggravated assault?
I plead nolo.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Okay. Yes.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Ballard. Your Honor, if this case were to proceed to trial, the state and the facts would show that on June 8th, 2024, officers of the Atlanta Police Department responded to 543 10th Street Northwest, that's in Atlanta, Georgia, also Fulton County, in response to a fight in progress. When the officers got there, they spoke with the victim, in this case, Mr. Hoffman, who told the officers that him and his fiancee, Taylor Fields, was at that location. I believe it was a Papa John's location to pick up a DoorDash delivery. Once they got there, there was a car that parked behind them that was blocking them from leaving. So they asked the car behind them to move and didn't understand why they were blocking them in. When they asked the driver and the people in the car why they were parked behind them, blocking them, a person in the passenger seat threw out a styrofoam cup toward the couple, Mr. Hoffman and Ms. Fields. At this time, Mr. Hoffman got the attention of a police officer that was in that same parking lot to kind of tell him what had just happened, and to try to avoid any confrontation between him and his car that was parked behind them. While Mr. Hoffman was going to get the officer's attention, Ms. Fields got out of the car to try to get the tag information of the vehicle that was parked behind them. Ms. Fields went around the front of the car. When she went around the front of the car, the driver of the car accelerated, hitting Ms. Fields. After this, the car drove off. Mr. Hoffman tried to stop the car because at this point they hit his fiance. When Mr. Hoffman tried to stop the car, the driver then accelerated again and hit Mr. Hoffman. Mr. Hoffman stayed on the hood around 8 to 10 seconds before he was thrown off. The driver of the car continued down the street and left the scene. At this time, the officers did respond, and EMS also responded to the scene. They both had injuries, but Mr. Hoffman was kind of in a worse shape than Ms. Fields. He had a gash and a laceration in the back of his head where he had to receive staples. Ms. Fields, in this case, she was scuffed up on her ankle and on her arm. However, most of her pain comes from her back and hands, as I've spoken to both of them in this case. At the time, the driver was not apprehended. However, she was through video technology and having her license plate, she was later identified, the defendant in this case, as the driver. Mr. Hoffman, when I spoke with him, he told me that while he was on the hood of the car, the person who was driving waved at him and smiled while he was on that hood before he was being thrown off. However, he did leave his phone on the hood of the car that was never retrieved. At this time, both of the victims in this case, Mr. Hoffman and Ms. Fields, was transported to Grady Hospital where they received treatment for their injuries. A warrant was taken out for the defendant in this case for the facts and circumstances and the 2 ag assaults we have here. She was later arrested for the charges that we have. And those are the facts and circumstances of the case. Regarding the recommendation from the state, because of the extent of the injuries and also the seriousness of the crime, the state is asking for a 10 serve 5 with the balance probated, and that's for counts 1 and 2 for both of them to be ran concurrent. Regarding the special conditions of probation, we're asking for the defendant to have no contact with the victims. This was a stranger on stranger type of thing, so just in case they run into each other again. For the defendant to stay away from that incident location again, that was like a Papa John's restaurant type of plaza. For the defendant to complete a defensive driving course and to pay restitution regarding the medical expenses. In this case, we're still waiting for those medical records to come back from Grady. However, I do believe that it's a large amount of money that Ms. Ballard may not, it's just a large amount of money. So we'll request a restitution hearing.
Okay.
I did want to share with the court pictures of the injuries from Mr. Hoffman and Ms. Fields. I've told Ms. Wood in this case that I would be showing the pictures during the plea.
Okay.
Is this something that you would like to see on your own, Judge, or would you like me to share my screen on Zoom?
You can share. I mean, this is, if there were a trial, I assume these would be pieces of evidence at trial.
Yes, Judge. 1 second. This is the injuries of Mr. Hoffman. He had to get staples in his head from that fall that he had. These are just other injuries on his arm. I don't know if that's gonna load. Oh, here we go. That's on Mr. Hoffman's arm. Regarding Ms. Fields, in this case, I do have a photo of her injuries. I'll share again. Most of the pain for Ms. Fields and her injuries came from back and arms, but this was kind of the scuffing that she had on the bottom of her foot. But those are the pictures of the injuries that I did want to share with the court regarding the incident we have here. The recording of the defendant in this case, accelerating toward Mr. Hoffman was also captured on camera, but it's a bit blurry. I didn't want to show that because I don't know if it would have shown much.
What was it, from a surveillance camera at Papa John's, or Mr. Hoffman was filming, or?
It was from across the street, so like a CCTV type of
Got it.
footage.
There was some stationary camera that was just for security reasons recording, and it captured some of what you described.
Yes, Judge.
Okay.
Also in this case, the state did get a chance to speak with Ms. Fields and Mr. Hoffman. Mr. Hoffman is on the call and would like to make a statement, a victim impact statement to the court. And I'll let him talk about most of how this has impacted him. But from Ms. Fields' side, because she's not on the call, she did tell me that after this, she became homeless. Her and Mr. Hoffman kind of split up, and that was because door dashing was their main source of income. And because they could no longer drive because of the injuries and make money, they could no longer pay for the apartment they were living in. So they kind of had to separate to go to different people's respective homes to have somewhere to stay. Ms. Fields told me that this has impacted her a lot with her relationship, her mental health, her physical health. And she would just like for the defendant in this case to be held accountable. But I'll let Mr. Hoffman also speak to the rest of the statement that he has.
Sure. Good morning, Mr. Hoffman.
Good morning.
I appreciate you joining us, and I'm sorry what you've been through. That was a pretty rough photo to see. I hope it didn't bring back too many bad memories for you of what you lived through. But why don't you share with me your thoughts about this situation, what you think ought to happen, the impact it's had on you. I'm here to listen.
All right, sir. If you don't mind, I've prepared a statement so I can just keep my thoughts in order.
That is okay.
I would just like to speak to the court today, make sure it fully understood the malicious and dangerous intent of the defendant. She did not She did not just act recklessly, she acted with complete disregard for human life. She laughed while the man she was with assaulted my wife by throwing a cup of soda and ice in her face. And moments later, she used her vehicle as a weapon to try to run my wife down. When I attempted to stop her from fleeing and pulled out my phone to photograph the car, she stopped in front of me. But the moment I raised my phone, she accelerated directly at me. I was forced onto the hood of the car, believing I was about to die. And she was laughing at me during this. She stared me in the eye and waved at me before violently jerking the wheel, throwing me off the car. This was not just an accident, it was deliberate, and the impact of that moment has stayed with me every day since. I suffered a severe head injury that required 10 staples, close a head wound the size of a soda can. I now live with a permanent scar, daily headaches, and hair that no longer grows where I was injured, a constant reminder every time I look in the mirror. My left ankle was also seriously injured. I can no longer stand for long periods of time without it giving out, which has permanently affected my ability to work labor-intensive jobs. As was said at the time, me and my wife were living paycheck to paycheck, and because we could no longer work, our lives spiraled into homelessness. Today, I'm sleeping on a floor in the living room, and my wife is sleeping on a friend's couch. I was terrified of even walking through a parking lot. This attack did not just injure us physically, it took away our stability, our independence, and our sense of security. This has changed our lives permanently. Your Honor, I ask you consider not only what happened in that moment, but the lasting damage it continues to cause every day. Thank you for your time.
You're very welcome, Mr. Hoffman. Tell me, are you and Ms. Fields, you've referred to her as your wife several times. I heard Ms. Smith refer to you as being engaged back in June of 24. Are you two still together?
We are. We're just not living in the same place right now because it doesn't make sense.
Sure, but you still are there for each other, just geographically, you can't afford to be in the same place.
That's correct.
Good, I'm glad you're still together. I'm sorry you went through this, and it sounds like it wasn't any easier for Ms. Fields, even though she might not have been injured quite as severely as you. I appreciate you taking the time to be here and to share what happened. It is always helpful to hear from the prosecutor, but it's somewhat necessarily a little sterile because Ms. Smith wasn't there. And so she's reading from reports and relating what she may have heard having met with you. But it's always more helpful for the judge to hear from the people who were involved. So thank you for your time.
Yes, sir.
Ms. Smith-Mann, do you have any criminal history information on Ms. Ballard?
Yes, Your Honor, I do. And I apologize if you hear another court going on. I'm holding two courts at one time.
That's all right.
But I do have some information on Ms. Ballard. There is one prior conviction, not including the one that is before you today. There is one open case out of Cobb County, 6/3/2025 for willful obstruction of law enforcement officers by the use of threats or violence. Nothing further, Your Honor.
What's the conviction that is out there?
It's not, that was one prior cycle.
So there is this Cobb arrest for
Yes, Your Honor.
obstruction, and that case is pending.
That case is pending, and the other case is a case that's before you. So there are two cycles.
Two cycles, okay.
One cycle is before you today.
Thank you.
You're welcome.
Ms. Wood.
Judge, just to let you know about that Cobb case, she had court there yesterday. We're expecting that to be downgraded. So it is still pending currently, but I'm expecting that to be downgraded for her.
So it's felony obstruction as alleged, and you think it will be resolved with misdemeanor obstruction?
From what she was told yesterday, Judge.
Okay.
Your Honor, Ms. Ballard is 22 years old. She was 20 at the time of this incident. She is local to the Atlanta area. She does have an 11th grade education. We are encouraging her. I'm going to ask that it be a special condition of probation for her to complete her GED.
I already added it.
Perfect. She was working at, so at the time of the incident, she was doing Uber Eats, DoorDash, that type of stuff. She also was working at FedEx, and she's also worked at Wendy's. She lost the FedEx job due to this case. So that is in part one of the reasons we will be asking for first offender treatment, is that so that we can, hopefully if the court grants it, this will not impede her ability to come back in for employment. She also involved in her church, 2819 church, and as you have seen from the letters I shared with the state and the court, she does have family and friends that support her and really believe in her. Your Honor, just to get some of our views of the incident on the record, I don't believe, from speaking with Ms. Ballard and my review of the facts, I don't personally believe there was malicious intent in this situation. The night in question, she was driving her friend's vehicle, and there were 3 other friends in the car with her. And as you heard, they were doing Uber Eats, DoorDash, and she unfortunately was not parked in a parking spot and had her hazards on. And so when the 2 victims confronted one of her friends, there was the exchange of words. And one of the friends did throw the cup with the drink or whatever. And so then it kind of popped off from there. My understanding of the facts is that the Miss Fields actually stood in front of the car, kind of laid on the hood, or was like, no, you're not going anywhere. You know, we need to get a cop involved. And at that point, that's when Miss Ballard unfortunately tried to maneuver away. It's my understanding she didn't actually run over Miss Fields, but she, kind of started driving. And so then Miss Fields was knocked to the wayside. From my view of the CCTV footage, and from reviewing the body cam interviews with Mr. Patrick, he runs to get the cop. Well, then she's already leaving the scene. And so my view of CCTV footage is that he actually sort of jumps on the vehicle, not that she accelerated towards him, but I understand everyone has their perspective. And so that's what we saw in the CCTV footage. So that would just be something the jury would have to decide at trial. But in any event, he was injured, and we understand that he's had to go through a lot. So she is accepting responsibilities. She just did not mean for any of this to happen. Obviously, everyone involved could have made better decisions that day, Judge. We have no issue with a no contact, obviously, no issue with the stay away, of course, no issue with the defensive driving course. And of course, we would be requesting a restitution hearing. I'm asking for first offender treatment as well, which I've already mentioned. I'm asking for a sentence of 7 years probation. We don't have any objection to weekends in jail. I've already went over that with her. And so really, Judge, that's our request to the court.
Okay. Ms. Ballard, do you have any kids?
No.
Do you stay on your own, or do you stay with friends or family?
Yeah, like friends, family, back and forth.
You're moving around?
Yeah.
Okay. Is there anything you want to add? You don't have to say anything at all, but you have a right to be heard, just like Mr. Hoffman had a right to be heard. If there's anything you want to say.
Okay. You want me to say it? Okay. Judge, we talked about it in the hall and correct me for this case. She completely denies laughing at anyone or pointing fingers. I don't know the other 3 passengers. I can't speak for them. Our investigator worked very diligently to try to get in touch with them. And of course, they are not answering our calls. So I can't speak if any of those people were laughing, but she is adamant she was not laughing. She was not being disrespectful. She really was scared after the exchange of the person in her car with the 2 victims. She just kind of freaked out. And so she wanted to make sure the court understood that.
Okay. Ms. Ballard, the other 3 people, first of all, was it your car or someone else's car?
Someone else's car.
Okay, but you were driving?
Yeah.
The other 3 people in the car, did you know them?
Yeah, well, yeah. It was one of my homegirl, and then her boyfriend and his friend.
Okay, so you knew one person real well.
Yeah.
And then you probably knew her boyfriend.
Mm.
And then this other guy was kind of a stretch as to whether you knew him.
Yes.
Who was seated in the front seat next to you?
The guy I really didn't know so well.
Okay, the one who was most stranger to you.
Yeah.
And then your girlfriend, person you knew well, was in the back seat with her boyfriend.
Yes.
Okay. And why were you all doing DoorDash together?
Because we just needed some extra money. So she had the car, I knew how to drive.
Got it. Okay, so it was a collective effort. Someone could contribute wheels, someone could contribute driving
They
skills.
got out and got the food. Everybody.
It's a real team effort. Okay, all right. Well, Ms. Ballard, I find that there is a factual basis for your plea. I understand that it's a nolo plea, but that doesn't mean that there isn't a sentence that accompanies it. And it certainly sounds like if this went to trial, a jury could find you guilty of assaulting both Ms. Fields and Mr. Hoffman. I'm not ignoring what Ms. Wood said. You'd have a defense. You might even choose to testify to talk about how you were scared and it wasn't intentional or who knows what. But it doesn't change the outcome of the pretty serious injuries. I think you're fortunate that you're not dealing with a vehicular homicide case instead. When a head hits the pavement, all sorts of things can happen, as you could see from that picture. I also find that your plea is knowing and voluntary. Voluntary means you are entering this plea because you've decided that's the way you want to move forward. And knowing means you've understood the things we talked about. Do you agree with that?
Yes.
Okay, I'm going to accept your plea. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, for you?
Yes, Judge.
And Ms. Ballard, is it okay if someone in my office signs this as a first offender nolo plea for you?
Yeah.
All right. We will defer restitution to another day. If the state marshals the information and wants to move forward, then we can certainly have a hearing as to that. Ms. Ballard, first offender is an opportunity that is available to you because you have no prior felony convictions. It means that whatever sentence I give you is a sentence and it's very real and you have to do all the things as part of it, but you're not a convicted felon. And if you successfully get through your sentence, then you can have this part sealed off. Should you go back to school or apply to other jobs, that's helpful. You ran into that issue with FedEx. You'll continue to run into that issue until this gets sealed up and you can have things sealed as a first offender. Assuming you successfully complete your sentence, it can stay sealed. The risk is that if while you are under sentence, and whatever sentence I give you, what the state asks for, your lawyer asks for, or something in between, it's going to be long. It's not just a few months. If during the course of that sentence you get in trouble again, not only do you have your new situation, but you'd come back here and the state would likely ask me to take away your first offender and resentence you. And you've got some pretty serious exposure here. The maximum you could get in this case is 40 years, 20 plus 20. I don't think that's what would happen if I took away your first offender status. But if what happens 6 months from now or a year from now is you hit someone with your car, I'm certainly going to take away your first offender status and there'll be a bunch more time. So if you're pretty sure that something like this wouldn't happen again, then first offender makes sense. But if you're working through some challenges that led to this and whatever was going on in Cobb last year, then first offender might not be a great idea. Do you feel like you understand the risks and the benefits of first offender?
I understand.
Do you want to be sentenced as a first offender?
Yeah.
Okay, I'll do that. Ms. Ballard, I am going to sentence you on count 1 to 6 years to serve 1 year with the balance probated, and the same on count 2. So you are going to have a custodial sentence. I'm open to letting you turn yourself in, not today, but soon if you need a few days to get your affairs in order. But if you are ready to go into custody, then that can happen today. I'm going to let you talk with Ms. Wood about that. Let me finish the sentences. It will be a special condition of your probation, and you'll have 5 years of probation, that you get your GED. You may do that while you're in custody, in which case you don't need to worry about it when you get out. You can have no contact with Mr. Hoffman or Ms. Fields. You'll need to stay away from that strip mall on 10th Street. And I'm not going to require a defensive driving course. Just you are driving again, you need to, of course, make different decisions while you're driving, to include not drive if someone is on your hood, but to keep the car stationary. So that's where we are. Do you need to talk with Ms. Wood for a minute about turn in?
What am I turning myself in for?
That's the sentence. So we need to talk.
Sure, you guys should talk. Do you have any questions about the sentence, Ms. Wood?
No, Judge.
Ms. Smith? Okay, all right. But so we're clear, we're not in a final plea setting.
Well, we preserved our rights, but.
Oh, you did?
Yeah, we did, because we were waiting on the medical, I think I'll be back.
Okay.
I'll be back though.
Okay.
Thank you, Judge.
While they're talking, Ms. Cabrera, should we do Mr. Lee? Mr. Lee, come on up, please.
I believe you, Mr. Davis is ready. He had a case in Newton County, so that's, I was actually waiting on him initially.
Sure, assuming we've got time. We've got our monthly bench meeting at 12:15. So if we can do it before then, we will. If that's a plea that's going to take a while, I know there are a lot of folks who want to speak on behalf of your client, then we may need to do that after the bench meeting is over. But let's take care of Mr. Lee and then sort out what's happening with Ms. Ballard, and then we'll take everyone's pulse. All right, Mr. Lee, let me get your case up here. That is position 11. So this is 25 SC 005-884, State versus Omarian Lee. He is here with his lawyer, Ms. Cabrera, and Ms. Smith is handling this for the state. And Mr. Lee, it's my understanding that you are ready to go forward with a plea. Is that correct?
Yes.
Okay. Ms. Smith will put you under oath, ask you the kinds of questions you've heard other people be asked throughout the morning. This time you're answering. Make sure you answer truthfully and completely. If you have questions of your own, you need to let Ms. Cabrera know or let me know. Will you do that?
All right.
All right. Ms. Smith?
Thank you, Judge. Mr. Lee, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Omarian Lee.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone to school?
18, still in school.
So where are you going to school?
Skyview High School.
Say it again.
Skyview High School.
Skyview.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So
Mr. Lee, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
Why she asked me, do I got one?
No,
Oh.
there aren't any. There are no outstanding warrants.
Got you. Mr. Lee, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on this charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you on probation right now?
Yes.
On probation.
Okay.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia, or any other jurisdiction?
No.
Not as an adult. So he has a plea that he's taken in juvenile court, but not as an adult.
Gotcha. Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained what the First Offender Act is to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for this charge in this indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Lee, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
As to indictment number 25 SC 005884, how do you plead to count 1, robbery by sudden snatching?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Lee. Your Honor, if this case were to proceed to trial, the facts would show that on October 24th, 2024, Officer Crowder responded to Piedmont North, that's 175 Piedmont Avenue, Atlanta, Georgia, also Fulton County, regarding a robbery. When the officer got there, they spoke with Vincent Wilkerson, that is the victim in this case. He told the officers that while walking in this area, 5 males came up to him and approached him. Out of those 5, one of them snatched his headphones off of his face, and then one of those guys took his Balenciaga shoes. At this time, at first he didn't want to give it up, but eventually, because he was scared or nervous, he gave up the headphones and also the shoes. The following day, on October 25th, 2024, the headphones that they took from him were like AirPod Maxes, so you're able to track them. The victim in this case was able to track his headphones being at 5134 Old National Highway, College Park, that's Skyview High School. The officers went to the school, and there was a video of this incident also. So the officers went to the school, they met with the principal, and they showed them the video to see if the principal would be able to identify the people in that video that was involved in this robbery. The principal was able to identify the subjects or the people that was in that video, one of those people being Mr. Lee in this case. Because of that, Mr. Lee was detained and eventually arrested for robbery by snatching. But before he was arrested, he was read his Miranda rights, he was interviewed, and he confessed that he was there on that day, and he did take the headphones of the victim.
The headphones were returned back to the victim in this case. However, the shoes was taken by another co-defendant that is indicted separately. So with the facts and circumstances of this case, it occurred in Fulton County, and those are why we have the charges of robbery by sudden snatching in this case. Regarding the recommendation, the state and defense, we've agreed to 7 years probation. Regarding the special conditions of probation, we're just asking that the defendant have no contact with the victim, to stay away from the incident location, and complete an anti-theft course, and also complete 60 hours of community service. The state understands that the defendant in this case does have a juvenile case for entering auto. I believe that was back in 2023. Right now, the defendant also has, that juvenile case. He's involved in the youth program. I think that someone's here from the youth program to speak on his behalf. But regarding that juvenile case, I did speak with Mr. Pena, and he told me that Mr. Lee has been very successful in the program. They've been able to work with him with no complaints. That kind of factored into the decision of the recommendation from the state and the agreements of with defense. But that is all from the state, Your Honor.
Okay.
Oh, I'm sorry, Your Honor. I did get a chance to speak with the victim in this case. Originally, we did refer this case to diversion. It was rejected. One of those reasons was the victim in this case did not want the case to go to diversion. He did not want the victim to get a slap on the wrist. He did say what happened to him, even though he was able to get those headphones back, was kind of traumatic. He now goes to school out of state. He was going to school at this location.
He was a Skyview student also?
No, at the original location of the robbery. I believe it's like Emory, or it's some type of campus.
Okay, trying to think what's on Piedmont, but he was a student wherever he was. Okay,
He since transferred. I think he lives in Washington, D.C. now.
okay,
I did give him the Zoom link to the call. He said he's at work, he can't come, but he did want me to at least give that statement to the court.
sure.
And that's all from the state, Your Honor.
Okay, thank you.
Excuse me, what's the name of the program you mentioned? The U program. The Opportunity Unit.
Like YOU?
Yes.
Okay.
YOUTH, Opportunity.
Oh, Youth Opportunity. Got it. Ms. Smith-Mann, any adult criminal history for Mr. Lee beyond his arrest in this case?
For 12?
No, Your Honor, just the case before you today.
Actually.
Great, thank you.
You're welcome.
All right, Ms. Cabrera.
Yes, Judge. He is asking to enter this plea under first offender. We were also inquiring about the behavior incentive date. Ms. Cheney is present. She may want to speak in regards to him. This program, as I understand it, is a 12 to 24 month program supervised by one of the judges that is there. Like the state says, he's doing well. He's still in high school at Skyview. He should hopefully graduate at the end of this year. I believe in December. He's taken interest in photography, has someone to assist him with that, and he's currently a new dad. So all very interesting things. I don't know if Ms. Cheney has something that she may want to add, because she has been with him in court. The last time I know, she was definitely present in support of him and very interested in how this case resolved.
Okay. Ms. Cheney, anything you want to add?
He's just been doing very well in the program. Second, graduated from the program in July.
In like 2 months?
Yeah.
Okay, and Youth Opportunity is what the program is called?
Under Judge Crawford.
Okay. Youth Opportunity. Did you say there was one more word, or it's just 2 words?
Unit.
Youth Opportunity Unit. Okay. All right. And that's something he's been doing in connection with his entering auto case.
Yeah.
Got it. Okay, thank you. Mr. Lee, you're a dad.
Yes.
At age 18. Boy or girl?
Girl.
Okay. And where does she stay?
Well, her mom.
Okay. How old is her mom?
She
16. Is she a student somewhere?
she go to Phoenix.
Pardon me?
Phoenix.
Okay. All right. Anything you want to share? No?
No.
Okay. Well, Mr. Lee, I find there's a factual basis for your plea. You and Jacoby Johnson and Vincent Russell, and it sounds like a couple other guys, had a dumb plan. It's good no one got hurt. It's good Mr. Wilkerson didn't pull out a gun and shoot you in the head. And he would have been justified in doing that, and that would have been tragic for your family. And you wouldn't be a dad. Obviously you need to not do something like this again. You're using up your first offender on this one. So if something like this happens again, you don't get to hide behind, I've never been in trouble before as an adult. And you're legally an adult now. So it's the serious times. I also find that your plea is knowing and voluntary, meaning you've understood the things we talked about. Do you agree with that?
Yes.
And voluntary, no one's forcing you to enter this plea?
No one.
No one. Good. Mr. Lee, I have in my hands a form called Plea of Guilty. You put your initials next to a whole bunch of things and talked with Ms. Cabrera about it. Did you sign this document on the second to last page?
Yes.
Did you understand it?
Yes.
And Ms. Cabrera, you signed it as well? Ms. Cabrera, can someone in my office sign the indictment on your behalf?
They can.
Ms. Smith?
Yes, sir.
And Mr. Lee, can we sign your name to the indictment indicating your first offender plea?
Yes.
Okay. It sounds like, Ms. Smith, there's no restitution. I mean, there are these shoes that are missing, but you're not moving forward for restitution at this time. Okay. So guys wear those kinds of shoes? Yeah. All right. Interesting. Mr. Lee, I'm going to sentence you as has been negotiated. I would have probably done a little less probation, but I understand the value of having a longer off ramp to keep you on point longer. 7 years probation. Special condition number 1 is that you graduate from Skyview or get your GED. And that happens within the next 12 months. So either you graduate, sounds like you'll be doing that in December at the latest, is that right?
Yes.
Okay, or you get your GED, 12 months. No contact with Mr. Wilkerson. Is Jacoby Johnson someone you know?
Yeah.
Is he at school with you?
Nah.
Okay, no contact with him. Is he a neighbor?
Nah.
Okay, Vincent Russell, do you know him?
Yes.
You're laughing, why are you laughing?
Because his name.
Okay. Well, funny or not, that's a name you got to stay away from. Is he at Skyview with you?
Nah.
Okay, stay away from him. You'll need to complete 60 hours of community service. You need to do that within the first 6 months of your probation. And you need to complete the Youth Opportunity Unit. Sounds like you're almost there, but it also sounds like that has been helpful for you. If they tell me you flunked out or whatever happens, then that's going to be a violation of your probation. I will set a behavioral incentive date of May 8th, 2029. That's 3 years from now. If you have done all the things you needed to do and stayed out of trouble, 0 arrests, then we can end your probation early. But if it's been bumpy, you haven't been showing up for probation, you're not doing the things you're supposed to do, then 4 more years probation. That's fine with me. But you could earn an early exit from the sentence. And I will sentence you as a first offender. I believe you understand the benefits of it and the risks of it. Ms. Smith, anything else for the state?
Nothing further, thank you.
Ms. Cabrera, on behalf of Mr. Lee?
Nothing here.
Mr. Lee, what county do you live in?
Are you in Fulton County?
Nah.
Where are you?
I'm on the west side.
Are you in Atlanta?
Yeah.
That's Fulton County.
Oh.
Unless
Okay.
you're south, but.
Yeah, Fulton County.
Fulton County. All right. You're going to need to report to probation in a little bit. Ms. Simpson, who's seated there in the jury box, she's going to come meet with you and Ms. Cabrera real quickly to just get contact info for you. She's going to give you a piece of paper. It's going to tell you when you need to show up for probation. That is a hot date. Do not miss it. If you miss it, they're just going to send me a warrant and there goes your behavioral incentive date. Okay? Any questions?
Nah.
How'd you get here?
Bus.
Where are you supposed to be in school now?
Yes.
You going back to school today?
Nah.
Why not?
I only do morning session. I can only do morning session. I can't do afternoon session.
Why not?
Because I can't. I got suspended for fighting.
At school?
Yeah, and I can only do morning.
When did you get suspended for fighting at school?
I don't remember.
Well, give me a hint. Yesterday?
No, didn't happen.
A year ago?
Nah, probably like a couple months, 2 months ago.
Okay. And do the folks at Youth Opportunity Unit know that he was suspended?
Yes.
Okay. All right. Good luck, Mr. Lee. I really hope, don't take this the wrong way. I hope I never see you again. That would be a good thing for you, unless I run into you because you're successful at doing whatever you're doing outside of the courts. Thank you, ma'am. Good luck with everything else. We'll send an email out about, yeah, I'm getting conflicting info about Mr. Melnick's availability. So,
Oh, the court is saying something different?
well, not the judge, someone else in the chambers. And then Mr. Abadi shared what he shared. I'm gonna go with what the judge says. So I need to shoot her an email. I've just been stuck out here.
I get the impression that the trial was ending. I just don't know that they know when.
Juries will do what juries do, right?
But I think that they're done. I think everything is locked.
Oh, I'm sorry.
Okay.
I'm so sorry. Judge, can we wrap up on this ballot?
Yes.
Please. Oh, yeah. I'm having no, I'm sorry.
All right, Ms. Ballard, we're going to get back on the record in your case. You and Ms. Wood had an opportunity to discuss. I sentenced you differently from what Ms. Wood advocated for. I understand why she was pushing for a probation-only sentence. The state, of course, was advocating for 5 years in custody because of the seriousness of what happened and the nature of the injuries and their perspective that it was malicious on your part. I wasn't there, and I'm not going to attribute any particular intent on your part other than that it was clearly reckless, and recklessness can lead to criminal liability. And it was real serious. It wasn't just one person, but two people who were injured. So it may have been some fear on your part, but it also, you were operating a dangerous weapon in the form of that car. And so I came up with something that was in between. I think that's reasonable, but it's also serious. Ms. Wood, does Ms. Ballard want to go forward with the plea, or does she want to withdraw her plea and go forward with trial?
She wants to go forward with the plea, Judge, and we would be requesting a turn-in date.
Okay. Ms. Ballard, I am open to the idea of you coming in here a little bit later. I don't mean today, but another day. How much time was Ms. Ballard thinking?
Full ask, Judge. I was going to see if the court would give her a couple of weeks, maybe have her come in on June 1st, which is a jury selection date for us.
You won't be here then.
I won't be here.
Okay, but you'll have a colleague here?
Yes.
Okay. Ms. Ballard, let me tell you how this is going to work. I will give you that reporting date. So you need to be here. You come to courtroom 8D. You've been here before, so you know how to get here. 8D, you need to be here at 9 o'clock. If you are not here by 9 o'clock and no one is reaching out to say she's on her way, flat tire, or the bus was late, then I'm going to go with the state's recommendation, and your sentence will be 10 years to serve 5 years. And you'll be a fugitive. You're not going to be hard to find, and your sentence will have grown by a factor of 5. So don't be late. If something comes up,
Can I do another date?
What's wrong with June 1?
That's too soon. Like, I have to get stuff in order.
It's not going to be sooner than June 1. I'm sorry, it's not going to be later than June 1. June 1 is stretching it way out. My inclination was going to be, how about Monday? As in, today is Thursday, I'll see you next Monday. That's what I would typically do. Ms. Wood has asked nicely. You have, for the most part, stayed out of trouble. I don't think you're going to do anything to Ms. Fields or Ms. Hoffman, Mr. Hoffman. I think they'll be safe during the time you're putting your affairs together. But June 1 is as far out as I'm willing to go. If you want to pick a day in May that you'd like to be here, that's fine with me. But June 1 is as late as it's going to be. Okay? So 9 o'clock, June 1. Do not be late because you'll get the sentence that the state asked for. Understand?
Right.
Okay.
Thank you, Judge.
You're welcome.
Judge, can I connect back to
Mr. Lee? Yeah. Can you get Mr. Lee? I think what we're gonna do, just to manage everyone's expectations, we're gonna do the bond hearing. And then we're gonna need to break. So we'll need to do Mr. Cobb after lunch and whatever else is here. Hey, Mr. Lee, come on up to the podium. I hope we're not already off to a bad start.
So I was trying to obtain an address from Mr. Lee, and Mr. Lee advised me that he jumped from house to house. And so I advised him that we would have to classify him as homeless because he cannot provide a stable address. He was not in grant for that. So I need to advise Mr. Lee on the record that the reporting date is May the 14th at the Atlanta Probation Office. I will provide the paper to you. However you work that out is up to you, but if you do not report on that date, you are automatically in violation.
And I'm asking for a warrant if he's not there for his intake. Mr. Lee, I've got an address of Benidorm Court.
Yes.
What's that?
My grandma address.
Okay. Is that not where you stay?
No.
Where do you stay?
Hey, wherever I lay my head at.
Okay. Well, the important part is report to probation that day. If you continue to tell people you stay where you lay your head at, they're going to classify that as being unhoused. And that's going to mean you're going to have to report to probation once a week. That's a pain, but that's just going to be the breaks until you figure out if there is a stable place for you to stay. Any questions about that?
Nope.
Okay. What day do you have to report?
May 14.
All right. And you'll get him a piece of paper? All right. Go back out with Ms. Simpson, please. Ms. Favors? Maybe she went outside.
Judge, I sent you an instant message.
Okay. Are you Robinson Keene?
Yes, sir.
Good. I'll take care of this before I break for lunch. I haven't forgotten you. I'm sorry the delay.
It's okay.
Got stuff going on. Let's see what we have left. I think we have Mr. Cobb's plea, which we'll do after lunch. Okay, I tell him I'm sorry. But we'll do that after lunch. Ms. Dublette, are we bringing her out?
Probably, I'm sure it's gonna be a trial, then we'll go talk to her.
Okay.
And you can talk, if you need to talk to her.
We'll do it after lunch.
Okay.
I'm just seeing what we can fit in. So we'll do the brief bond hearing on Mr. Thomas now, and then we'll break for lunch. And we can take up Mr. Cobb's, let's just say 1:30.
Oh, yeah, if that, yes, his grandmother has a doctor's appointment, she was asking, she had no money to get there without them, so we did that first thing, possibly.
It's all that's left is Cobb. What do we have?
Cotton by me.
Oh, Mr. Cotton's gonna be a plea. That's new to me. Okay. Well, should then Ms. Tembeka talk with Mr. Thomas a little bit more?
I still haven't seen the discovery.
All right.
It's happened so quickly.
Yeah, well, I'm not expecting you to be in a position to counsel him on that. but you had wanted to have a bond hearing. Do you want to hold off on that? Because so many things are in motion that there may well be a resolution, not today. We can bring him back after you've had a chance to look at discovery.
Judge, and to be perfectly honest, it would be my preference to come back. However, when I spoke to him, he was pretty adamant that he wanted, despite all of the benefits of potentially living, he really wants the opportunity. I do understand.
Okay, then let's do that right now. This is what we need to do. So let's bring Mr. Thomas out. I couldn't find Ms. Favors. Oh, you're Ms. Favors. Hey, Ms. Favors, I've signed your paperwork. Good luck with things, okay?
Yeah. Yeah.
Ms. Dublette, we'll see. Do you mind just being right where, or you can move if you want. Just stay where you are. Okay. Let's get on the record in 25 SC 006136. Mr. Thomas is back out here with his lawyer, Ms. Tembecca. And Mr. Thomas, a few things are moving in your case right now. One, it sounds like Mr. Cotton is going to enter a plea. I'm going to do that this afternoon. Two, you've got the lawyer recently joining your defense. She needs time to process all the discovery and the fact that your co-defendant is entering a plea. But we're going to talk real briefly about bond. So I'm going to hear from Ms. Tembecca. She is going to learn more about you and your case after she has more time. But she has shared with me that you really, really want to be heard on bond. So I will listen, but I don't want you, if my answer is, I'm not going to change things right now, to despair. As Ms. Tembecca learns more, she may say, can we talk about bond again? Because I know a whole lot more about the case. It's not her fault that she doesn't know about the case right now. If we're together in a month and she says, I don't know anything about the case, we should all fuss at her. But today isn't the day for you to say, come on, you didn't know this or that. So she is on the fly going to advocate for bond. I'll hear from Ms. Smith, the prosecutor, about bond, and I'll let you know what I'm going to do.
All right, Judge, thank you. So with respect, Your Honor, to community ties, he is a Georgia native. He's been here his entire life. His family is here. He's a generational Georgian. Mom is also from here. Grandma's present. They're here. Your Honor, at the time of this alleged incident, he was a minor and he resided in the home. It is my understanding that should he be released on bond, he would be able to return to the home if the court is so inclined. Judge, we would also like to note, and getting a little bit ahead of ourselves in terms of if the court is inclined to set a bond, this is a 4 co-defendant case, and two of the defendants are actively out on bond. One is out on a $12,500 bond and the other is out on a $30,000 bond. So if the court were inclined to grant a bond, we would ask for something, within that range, Judge. Like I said, he's a Georgia native. He's had all of his education here. His parents are here. He's got a child here in Georgia. He wouldn't flee the court's jurisdiction. He would return when called upon. It's my understanding, and they will confirm, of course, that he's without felony history. He's without juvenile history. And so we just believe that he is a candidate for bond, that he wouldn't pose, a risk to anyone in the community or, all of our standard Ayala factors, Judge. And I know that's the state's burden. So I'll go ahead there and allow the state to address the court.
Okay, I was just looking over the docket. It looks like a bond was never set. He was indicted so quickly after his arrest. There was the SB 440 hearing and then boom, he was indicted. So here we are. Mr. Thomas, you have a kid?
Yes, sir.
Boy or a girl?
Boy.
How old?
1.
All right, does he stay with his mom or with some of your family members? All right, Ms. Smith, your thoughts about bond for Mr. Thomas?
Yes, Judge, in this case, the state will be requesting no bond on the charges that we have. Two reasons, the state does believe there may be some witness intimidation in this case. There are claims that the ID and identification of the victim in this case was taken. We're not sure if there was a copy made, if they know who she is, if they know where she lives. So we do believe there's a risk of witness intimidation. Also, we believe that there's a risk of the defendant being a danger to the community. The allegations in this case is that it was the defendant, the sole person the only person in the car who had the gun. Everybody else in the car says that it was the defendant who had the gun. If the defendant said he had the gun, also we went to talk to the police officers and not to get too much into the case. But because of that, because of the role that the defendant played in this armed robbery, the state will be objecting to any bond being set based on the facts and circumstances. I did speak with the victim in this case, and regarding all defendants, she would oppose bond, but especially for Mr. Thomas in this case, because he is the one who allegedly had the gun on the day of the robbery.
Does I'm looking a little bit at this information. Ms. Pierre is the victim?
Yes.
Were these all strangers to her, or did she know one or more of the people? It's an interesting spread in age of who's in the car.
Very interesting, but she knew prior to that name one person, Ms. Chambers.
Okay. Got it. So she knew Ms. Chambers and then says these other people in the car, and she attributes the firearm to Mr. Thomas.
Yes.
Okay, and you're saying that others in the case have given statements to law enforcement, and they also put the gun in Mr. Thomas's hand.
Yes, Judge, statements to law enforcement and also to the state.
Okay,
Yeah.
got it. All right. Ms. Tembeka, anything else on behalf of Mr. Thomas?
Just very briefly, Judge, and I do understand the state's concern with respect to potential intimidation and being a danger. However, I would just state that that sounds more like it's just in the realm of possibilities. There's nothing to state that he poses significant risk of intimidating any witnesses. So I just want to put that out there.
Okay. All right. Mr. Thomas, I'm going to deny bond at this time. I think your case is going to start moving real quickly, given what's happening with your co-defendant and the fact that you have a very proactive attorney who is taking over and will be getting discovery. That said, if Ms. Tembeka, you run into any delays that are occasioned by the state, they're not getting you evidence or the court is slowing things down, I invite you to renew the bond motion because delays from the state or from the court aren't Mr. Thomas's issue. The state didn't cause the transition in lawyers, and they were ready to go on Monday with trial, which would get closure for Mr. Thomas. He's acquitted, he goes home, he's convicted, bad news. But at least then you don't need to worry about bond. We are delaying that trial because we need to give you a chance to get up to speed. And so I'm going to maintain the status quo, but with the expectation, I'll be reasonable about it, that you're going to move quickly to get done what you need to. And like I said, you may determine after you figure out the dimensions of Mr. Cotton's plea that there's something that makes sense for Mr. Thomas to do as well. Okay?
Judge. Yeah,
All right.
and Judge, it just in the event, as I understood the court to say that if there is some change and that we're able to file a bond motion, may I ask which is our basis for denial today so I can reference it if that factor changes? For
It'll be in the order that I will file an order denying bond and I'll check the boxes. It's not risk of flight.
Thank you, Judge.
You bet. What is a reasonable amount of time to give you, Ms. Tembeka, to get an email back to me and Ms. Smith and Ms. Nelson, my litigation manager, of, all right, I've had a chance to breathe. Here's what I need. I need a couple months to file motions or whatever that's going to be.
I mean, Judge, I anticipate, Ms. Smith, she's very on top of it, that, pretty soon I'll get those evidence links and I'll be able to review them. I mean, I feel confident in saying that by the end of next week, I should have that timeline for everyone.
Well, I'll make a note then that by, that's built into June, by the 15th, that's next Friday, we will have heard from you saying, hey, I'm ready for you to put it on a trial calendar in June, or give me another few weeks to process discovery. I'm pretty sure I'm going to be filing a motion that'll need a hearing, and we'll prioritize this and make it happen.
Thank you, Judge.
You bet. Mr. Thomas, do you have any questions about anything we discussed?
I'm sure.
Okay, we'll see you soon.
Now, Your Honor, that concludes my business. May I be excused?
Yes, thank you for appearing out of nowhere with no notice. That's
Thank
good
you.
service.
Thank you.
Ms. Rios, Ms. Dublette is burning a hole in Deputy Gordon's pocket in terms of needing to get her back. There are folks pressuring on the transport side. If you don't think I need to talk to her, if you could make that your priority, we're gonna break now. You could talk with her and then you can tell Deputy Gordon, we have spoken. And I have on my trial list now that got buried, we basically have Dublette, and then are we gonna be able to do the 5 defendant case or not? That's what, because Mack pled, Cotton is pleading. We can't make Thomas go forward yet, so it would be Dublette. So you should let her know she's coming back on Monday. All right? All right, Investigator Robinson Kane, I'm taking your documents and I am taking, I think it's Walden, but I don't want to, yep, Walden, I'm taking your documents. I'm gonna read those, I'll come back out and we'll knock them out before I have to get on this other meeting. All right, thanks.
You say 1:32.
Yeah, just to be, my guess is it'll be earlier. We don't have a ton on the agenda, but I hate making people wait. So let's just say 1:30. All right. Sorry, Mr. Cobb, you've been here forever. And I don't know how this plea is going to play out either, but I appreciate your patience. Go get lunch if you can eat. Hopefully your family can eat.
My son in hospital. Yeah, I don't know. I'm sure, but I never for them boys' sake, because they told him to stop, and he did. And the mom got it on recording. I don't know what she did with the video. She probably discarded it. But she gonna hold him for everything he do.
Please mute your devices.
Oh, somebody like something. Yes.
All right. So as I look here, I've sent an email to Judge Polk. Do you have is there a PD on the case? Is the case, yes, Ms. Rios has Mr. Patterson. So I've sent an email to Judge Polk. That'll be the final word because I've received conflicting information for whether we can go to trial next week with Raheem Smith and Harrigan, et cetera. DA's office was saying, we heard it'll be over soon. Someone on Judge Polk's staff was saying, we'll tell you late tomorrow. That's too late. So I went to the boss, and when I hear from her, I will let you guys know about Mr. Melnick's.
Cause I don't want my client near.
I figured you sit in the back with your client.
One client someone stabbed.
Yes, we will keep them far apart. We'll be in courtroom 1C.
Okay.
We won't be in here. We'll be in a big courtroom. So that's that case. Roby is for later. Mr. Cotton is going to plead.
Right now, yes.
Okay, well, should we,
I love this game. Last time I made promises, people came out.
should we do that first?
No? Mr. Cobb first, because his grandmother.
I would like to do it first, Mr. Cobb, but if Mr. Cotton is changing his mind, but we'll get back to that. And that's it then, I guess, unless Ms. Dublette has changed her mind.
Right now, that's a non-negotiated plea.
Let's get started with Mr. Cobb. Let's get started with Mr. Cobb. That seems the most certain. Are you ready? Okay. Then we're going to get on the record. It's position 27 on the calendar, 25 SC 006827, State versus Preston Cobb. Good afternoon, Mr. Cobb.
Good afternoon, Judge.
Mr. Cobb is in court with his lawyer, Ms. Rios. He is charged with 2 counts of serious injury by vehicle and 1 count of theft by receiving stolen property. At least that's what it says on the calendar. And Ms. Smith, representing the state, is going to start our plea conversation in just a moment. She'll put you under oath, and then you will be asked a bunch of questions you've already heard several times today. But it's your turn to answer the way you think is the correct answer. You need to make sure that you stop us if at any point you've got a question. If you're not following what's going on, or you just need a minute with Ms. Rios, will you let me know that?
Yes, sir.
Okay, then let's start.
Mr. Cobb, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Preston Cobb.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 20 years old and I graduated high school last year of May, 2025.
Where'd you go to high school?
North Clayton High School in College Park.
Got it.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Cobb, do you remember being arrested on these charges?
Yes, I remember being arrested.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Do you understand that this is a non-negotiated or blind plea and that the state would recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge.
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Cobb, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 006827, how do you plead to count 1, serious injury by vehicle, count 2, serious injury by vehicle, and count 3, theft by receiving stolen property?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right. Thank you, Mr. Cobb. Your Honor, if this case were to proceed to trial, the state would show that on.
Is Mr. Cobb pursuing this as a first offender?
Yes, Your Honor.
Okay, I'll cover that with him. Is that something the state is opposing, is neutral on, or what's your view on first offender?
Leave it in the court's discretion.
Okay, we'll get to that. You were going to tell me about the facts of the case.
Yes, Judge. On June 18th, 2023, officers of the South Fulton Police Department responded to 2929, I'm going to spell it, BETHESDA Road. That's in Atlanta, Georgia, and also Fulton County. When the officers got there, they saw that a car had crashed into a tree, and that there were passengers inside of the car that were injured. The officers that responded, also EMS responded. They were able to take the passengers out of the car. All of them were kind of banged up, so they all went to Grady to be treated. In this case, the officers, after doing their investigation, found out that the defendant in this case, Mr. Cobb, was the one who was driving the car at a high speed before it hit a tree. The car that he was driving was a 2019 Kia Optima. It was stolen, and the person who owned that car, the officers got in touch with her, and she said she never gave her car away. She didn't know who Mr. Cobb was, and that she had reported it stolen. So the car that was used in this offense was stolen. The officers were able to get a black box from that Kia Optima that showed that 2.5 seconds before the crash, the car was going 122 miles an hour. At the time the car hit the tree, it was going 88 miles per hour. So the car was going pretty fast. In this case, there were 4 other passengers in the car, not including the defendant in this case. However, 2 passengers in particular they had pretty serious injuries. One of those victims being Darrell Wilson and the other person being Boss Newton. In this case, all passengers were transported to Grady Hospital, but their stays were a bit longer because of the injuries that they had. Because of this, the officers were able to determine that because the defendant in this case was the one that was driving and that it was a stolen vehicle, warrants were taken out and he was arrested for these charges that we have before us. Those are the facts of the case, all occurring in Fulton County. Regarding the recommendation from the state in this case, for counts 1 and 2, the state is asking for a 10 serve 5 with the balance probated. And regarding count 3, we're just asking for 5 to serve to run concurrent with the 10 serve 5 recommendation in counts 1 and 2. Regarding the special conditions of probation, we're just asking that the defendant have no contact with either of the victims, to complete an anti-theft course, to complete a defensive driving course, and also that was the last thing for the special conditions of probation. The state in this case did reach out to both of the victims. At the time, they were, I want to say juveniles. Right now, they're still young, maybe around 19, 20. But I was able to speak with the mom of Darrell Wilson. She's on the call. She would like to make a statement. However, from what I've gathered, Mr. Wilson, who was the person in the middle back seat, he cannot talk, cannot walk. He has a brain injury. He has a feeding tube. He's kind of bedridden. He goes back and forth to the hospital because sometimes he gets infections from sitting too long. And I'll let his mother in this case talk a little bit more about those injuries. The state did try to reach out to the next of kin for Boss Newton. However, we were not able to reach anyone, but we did get a chance to look over those medical records. And Mr. Newton, I believe all of his teeth were knocked out. He does have a brain injury and had a couple of fractured and broken ribs and bones in his body. So we weren't able to get an updated how is Mr. Newton doing in this case because we could not find next of kin. However, Ms. Wilson's mother is on the call and would like to talk about kind of how Mr. Wilson's life has been since this injury.
Okay, and I'll hear from her in just a moment. The indictment in count 2 says that the particularly serious situation for Mr. Newton was something about his leg. So some of the bones that were broken were in his leg. You mentioned his teeth got knocked out, but I'm assuming there's evidence that something happened to his leg.
Yes, Judge. The medical records are, of course, very long, but those some of the bones that were broken were throughout his body, but in his leg also.
Okay, got it. All right. So on the call, there is a Jada's iPhone, and then there is a Treese. I may not be pronouncing that correctly. I'm not sure which is Mr. Wilson's mom.
It's Treese, it's me.
Hey, are you Ms. Wilson? What's your last name?
Thompson. My name is Latricia Thompson.
Ms. Thompson, I appreciate you joining us. Let me add you to the screen here so that everyone can see you. So you are Darrell Wilson's mother?
Yes, sir.
Okay. Well, I appreciate you joining us, and I am sorry what has happened to your family. We are almost 3 years into this, so whatever your son is having to deal with, if it's still going on, it sounds like tragically it's a permanent situation. Why don't you let me know how he's doing, how you're doing, and how this situation has impacted your family?
It's impacted us a lot, like, cause it changed everything. Now Darrell had to have 24-hour care with skilled nursing and unskilled nursing. His body contract like a baby fetus, so he can't stretch his legs out and he can't stretch his hands out, or his hands balled up. But I wish Darrell were here, but he had to go to the hospital emergency room because he was having a urinary tract, which he catched them throughout the whole 3 years. He been catching them back to back, so he had to go to the emergency room. So they changed his tubes and stuff like that. But he nonverbal. I wish Darrell was here so y'all could see him.
Well, you're
I'm not mad at Preston. Only thing I just want to know, Preston, like, if them church asked you to stop, why you just didn't stop, baby? Because you changed everything. I don't want to see you go to jail, none of that. I don't want to see, like, this going on with my son. But at the end of the day, like, they asked you to stop. That's the only thing that I just don't understand. If them boys asked you to stop, why you didn't stop? Cause Darrell didn't know none of y'all. He only know the boss. Boss introduced Darrell to them. And Darrell didn't go to school with you all. We had just moved to the neighborhood. We were new to the neighborhood, and he got the worst out of everything. And he just changed a lot. So I don't.
Do you know, Ms. Thompson, you mentioned that your son knew Boss Newton. Do you know how Boss Newton is doing? Do you have any information on how he's doing?
No, the last time I talked to them, it's been like a year ago, and he was at home and stuff. You know, he walked with a limp. He missing like his top and his bottom teeth, and that's about it. But he was functioning, talking well.
Okay.
The real,
So,
the real, the only one got the worst end.
got it. Do you know anything about what happened? There were apparently two other young men in the car besides your son and Boss Newton and Mr. Cobb. Do you know anything about what happened to the other young men?
No, sir. I only seen all them two. I only seen them when Darrell was in the hospital.
Yeah.
We didn't even know. I didn't even like. I thought it was some boys that he normally hang around. I didn't never know them. He ain't never go to school with them. Darrell, that was the first time meeting them.
Okay. And how is it that your household is able to afford 24-hour care? That sounds very expensive.
Yeah, through Medicaid, he received Medicaid. Medicaid helped us out.
Okay. Well, I'm glad that resource is there for you all, and I'm grateful.
I don't know. It ruined Mr. Because he ain't in the hospital, but if I turn, y'all can see he got a whole hospital bed. Like, feed it to, he stay on medicine.
Oh, yeah.
This him.
Okay.
He was in rehab, but he got a whole hospital bed.
Okay. Well, I'm glad that you've been able to care for him, and I hope you have help. It's not just you. I know you said that there's in-home nursing. Are there others in your household who can help?
His sisters, he got siblings.
Okay.
He got siblings.
Okay. Well, Ms. Thompson, it's been real helpful to hear from you, and our thoughts are all with Darrell. This isn't the kind of thing he's going to recover from. So like you said, it's life-changing for him. And here's Mr. Cobb standing in court. So it was a very different outcome for different people.
Yes. I just wish he would have stopped when the boys told.
Yep, I bet he does too. Well, you're welcome to stay on the call while we go through the rest of this, but thank you for being here.
Okay, you're welcome. Thank you.
All right, Ms. Smith-Mann, any criminal history information for Mr. Cobb?
Yes, Your Honor. There are 3 prior cycles that are not including the cycle that is before you today. There is a 2024 battery against a female who is pregnant in Clayton County School, and it's Clayton County School Police to be exact. There is a 2026 Clayton County death by receiving stolen property, willful obstruction by law enforcement officers, driving without a valid license. Nothing further, Your Honor.
All right, you said there were 3 cycles, and you told me a battery against a pregnant female. That sounds bad. And then very recently, driving without a license while you are awaiting resolution of a serious injury by vehicle case. But those were 2 cycles. What's the third?
The third cycle was a willful obstruction that was dismissed, a theft by receiving stolen property that was dismissed from Clayton County in 2023.
Got it. All right. Thank you.
You're welcome, Your Honor.
Ms. Rios?
Yes, Your Honor. I want to start with having Mr. Davis talk first about the next level.
Okay. Hello again, sir.
Well,
How are you?
Good, thank you.
We have taken up a lot of your time today. I apologize. You've been very patient and hopefully you've been able to attend to other things. You should cover whatever you want. You know, I'm familiar with the amazing work you and your program do. So I don't need to hear so much about that. I'm more interested in what you know, if you know anything yet about Mr. Cobb. He's in a real awkward situation right now.
Yes, just hearing the facts, just so unfortunate, you know, just my heart goes out to his family just to happen to just have a sudden change. These are a little different than me coming in front of him. Normally it's kind of straight to the point, but you know, I've had an opportunity. This young man has been in the program now. His attorney reached out, but I have some history with him. Some years ago, maybe when he was like 12 or 13, his family was bringing him on a preventive measure. He never made any type of trouble. They was brought into it. I think he came by way of someone from the church. And we really liked him. So there was a loss of contact. I don't know if it was a transportation issue or something like that. But, you know, I often try to, especially when I come in front of you, I try to explain, I'm sure you hear this all the time, how do we get here? Like, what is the codependency? How do you end up in a vehicle, whatever? And I'm sure 90% of the people that come before you, Judge, have some type of family dynamics that leads to this. This young man here, he lost his father, the weekend of his 8th grade graduation. He did begin to live with his grandmother and help care for her. And shortly after losing his father, he loses his grandmother. So he has all this trauma, all this depression, all this grief that's on top of all that. And I just think that at that time is he began to reach and search and try to find somewhat another family. And just the, you know, just unfortunate situation. And yeah, so he's been in the program, he's doing well. I just really wish that, had I known, I was really wished that the family would have been able to keep him with us. But I always just try to give them credit because they try to get ahead of it. I think when he lost his father and all that, they just wanted to get ahead of it. But again, it's so unfortunate. Great young man. He's been accepted to the program. You know the rest, how we work close with the courts. And should you grant him this opportunity, the relationship that we have with the courts and probation, that we would, even if we had to do some additional things to hold him accountable. But I just got a chance to get to know the family over the years. It's just so unfortunate. He's an amazing young man. So that's all I have to say.
All right. Well, I appreciate you being here again and thank you for the work that you do.
Thank you, sir.
One life at a time.
Yes, sir.
Ms. Rios.
Yes, Your Honor. In regards to this situation, this happened 3 years ago. At the time, he had just turned 18 years old. The friends that he were in the car with that are the victims in the case, they picked him up. It's basically a joyriding situation. They went to one of the friends' house, hung out, and they got back in the car with Mr. Cobb being the driver, and there was music playing. They were being rowdy teenagers, and mistakes were made. And they were very, very big mistakes that he regrets, and he's very remorseful of the situation. He also, he was even arrested for a while after the situation because he was also in the hospital. I know his injuries are not comparable to what the victims in the case are dealing with, but he had also a traumatic brain injury that he still suffers from, that's affected his intellectual ability. And he's ongoing seeing a doctor for that. He had other injuries with his leg, broken leg, collapsed lungs. So he was in the hospital for months and months, also dealing with the injury he just made. He has made a decent recovery, but is still suffering from that. As you know, 18-year-old brains not developed, not making the best decision, and unfortunately just had very bad consequences for everyone involved in the situation. So far, he's been trying to do well. He's now 20 years old. He graduated from high school. He has one daughter who turns 2 in July. He's employed. He's working at Amazon, preparing customer service orders. And he's been trying to take care of his child and help out his mom and do good. I do understand the seriousness of what happened and how this has had very serious effects for the victims in this case. I just don't believe him going to prison for 5 years serves anyone. We heard the mother of the victim in the case that she doesn't even think that he should go to prison. I get the serious.
I do. I think he should.
Yeah,
I do too.
Hey, both of you stop, Dad. You'll get a chance. It's not your turn right now, so let's not interrupt. All right.
This wasn't a malicious, intentional act. It was a thoughtless and an act of someone who did not have a fully developed brain at the time, being that he was a teenager. I'm asking for on count 1 and 2, the theft by receiving to be 10 years on probation, with the 5 years to serve on the back end and to suspend if he has no further convictions. And on count 1 and 2, and then count 3, the same sentence with if he doesn't have any trouble for those 10 years, for the 5 years in prison to be suspended, and for him to be treated as a first offender.
Okay, so first offender I get, and we'll cover that, but you're asking for one of these backloaded sentences where if Mr. Cobb over the next 5 years makes good choices and stays out of trouble and whatnot, then that would be evidence that he has turned a corner, and the remaining 5 years would be a sentence, but they would not be custodial. They'd be suspended so that if something happened year 6, one could still deal with it, but he's not in custody.
Yes, Your Honor.
Okay. So I'm gonna come to you in a minute, Mr. Cobb. Ms. Smith, I believe Darrell Wilson's father is now on. I don't know if you were expecting him. I'm happy to hear from him as well. He kind of barged in while Ms. Rios was talking. Is that someone you've had contact with as well?
I spoke with Mom, and she said that other family members may want to speak, including his dad. So
Okay. All right, Mr. Wilson, if you want to unmute, if there's something you want to share with me, I would like to hear from you now.
Yes, sir. How you doing today?
Well, I'm all right. This is a pretty sad situation that we're working through. I got to hear a lot about how your son's doing from his mom, and that was hard to hear.
Right. Well, I think he should get whatever Matt sent him because, my son did ask him to let him out the car. My son asked him to let him out the car, and he refused to let my son out the car. You know what I'm saying? And so that's one thing. And, I don't know what my son experienced doing that, but it's been a bad experience for me and his mom and his family and the rest of our family. My son almost died twice. We've been dealing with more than enough. Still to this day, we back and forth to the hospital and, all that. So, I ain't trying to keep y'all alone, but I think he should be getting way more than house arrest. Cause my son, what I'm saying, was, technically on the right path. They went all doing right, but my son didn't want to take that ride. And he made my son take that ride. So I don't think he should be getting no light sentence and none of that.
Okay, I appreciate that. I appreciate you joining us. I understand your perspective on this. And I am glad that your son has both you and his mom in his life trying to help him work through all this.
Right.
All right. Thank you for being here.
Okay.
Ms. Smith, both Mr. Wilson's mother and his father they've echoed each other that they believe at some point the passengers were saying either slow down or let me out. Is there something in the body of evidence you have about that? Or is that something that Mr. Wilson's parents would know because somehow he was able to communicate that to them?
So during the officer's investigation, one of the passengers in the car that was not severely injured told other family members that they asked him to stop and they asked him to slow down, but he refused. He went fast and he put up the music. But that's not something that the passenger said directly to officers. However, during their investigation, that is something that they became privy to.
Okay, so you've heard that theme as well. You're not hearing it for the first time from Ms. Thompson or Mr. Wilson.
That's correct.
Okay.
Excuse me, Mr. Young, sir. Man, his mom actually visited him while he was in his coma, and he said that himself, while he was in his coma, he said the rail asked me to let him out before he even put the car in drive. My son asked him to let him out the car. I don't know about nobody else, but he said out here on mouth that my son asked him to let him out the car off the rip. Cause my son, no, I don't even, he know better. So,
okay.
Yeah, I don't know what they communicate. My son couldn't communicate with the officer.
Right.
And Preston was the one that came to pick the boys up. Them boys didn't have no car. Preston was the one that came and picked them up. His mama had a video, but she deleted the video of him telling the story that them boys told him to stop. He said that himself when he was in the hospital because it wasn't nothing wrong with Preston. Preston, like he functioning now, he was functioning then. I ain't never known about a brain injury. His mama, she stayed by my baby bedside because she thought my son was gonna die. She the one called me and told me what was going on. I didn't even know that my son had been in an accident until Preston mom called.
All right. Well, I'm glad she called you. Okay. All right. Thank you both. Ms. Rios, I'm going to ask Mr. Cobb in just a minute if there's anything he wants to add, but I wanted to come back to you because we've been a little dynamic here in our exchange.
I want to make sure his mom she thinks she want to say something. And I also do have documentation from a doctor about his brain injuries.
Okay.
Severe.
All right. Well, what order would you like to go? Mr. Cobb, are you going to say, you don't have to say anything at all, but you have an opportunity to if you want to. You do want to say something? Yes. All right. Should we have your mom go first?
All right, I just want to just give an input on this case, because like I said, this is an unfortunate situation.
Okay, we need to start first with your name.
Oh, Brenda Cobb.
You're Miss Cobb. All right, Miss Cobb, and you are Preston Cobb's mother. Thank you for being here. It's good for him that you're here. I do want to hear from you. This isn't he said, she said time to say, oh, those Wilson parents don't know what they're talking about. That's not going to help your son right now. But I do want to hear from you about your son, because of course the part I'm focused on is the terrible decision he made that night. And I know he's more than that. He's been alive for 20 years, so there's good in there as well. And so if you want to tell me about that, I'd love to hear about it. I heard some already, but you are uniquely positioned to help me understand that Mr. Cobb is more than a kamikaze driver in June of 2023. Whenever you're ready.
I'm ready. So since this incident happened, it has impacted Preston. Preston, of course, all of them were in the hospital. Of course, I reached out to the family because no one could contact them. And the officer that was on the case said, hey, this is their address, because no one could contact the family, or whatever. So I ended up getting the address and knew where that was, which was near my house. And I was able to go to the door and, hey, it was hard for me to go to somebody and say, hey, your son has been in an accident, but hard for them to ask, well, what happened? Who did it? You know what I'm saying? And, it's hurtful for me because everybody's life has been impacted. You know what I'm saying? His life has changed forever. Everybody's life has changed forever. Even when we was in the hospital, I was by their side because I felt their pain. Even though my son was on one level up,
I was down there on their level too, because it was I felt it was my duty to be there for everybody. And Preston did go through, he was in a coma too. He couldn't speak, you know. He still today, you know, has issues remembering things. I have to coach him, you know, I have to pretty much baby him, but he's in a form where he can move. So it has impacted him as well. You know, no parent would think that they will go through something like this because I didn't raise Preston. He didn't grow up in a household to hang with the wrong people. You know, I didn't raise him. I've always coached him to make the right decisions. And unfortunately, it happened. He's accepted, and he's accepted what he did was, you know, wrong by getting behind the wheel. But Preston he was picked up from my house. It was on camera. He was picked up, and that was given, all that information was given to the officer. And you know, what happened after him getting behind the wheel or what made it happen, I wasn't there. I don't know what played a role in or what was going on in the car. You know, he don't even remember what happened still to this day. He just know I blacked out. We don't know.
Your son was
but-
talking in his coma.
Mr. Wilson, I'm gonna have to have you drop from the call if you keep interrupting, okay?
And, you know, it is an unfortunate situation, but since, you know, Preston, he didn't just get out the hospital and come home. He left the hospital after being there for a period of time. He had to go to the Shepherd Center. He had to learn how to re-walk. It's a lot of things he had to do, and then when he came home, he had to have a nurse come in and look after him while I was at work, and still me having to take him to physical therapy. So it wasn't you know, I got out and he you know what I'm saying? He had to go through some things as well. But you know, since it has happened, you know, Preston has stayed out of trouble. He has finished high school. He has maintained employment for the past 3 years. So that just, you know, right there speaks level, because he could have had this and continue getting in trouble. You know what I'm saying? And, you know, I just, you know, want to say to the family, I'm sorry that happened, because, you know, we never expected this, you know. We never expected this. We, as parents, we can coach our children and, you know, hope they do the right things, but, you know, I'm not here to put the blame on nobody, child, because all my kids made a bad decision, and that, unfortunately, it has changed everybody's life, regardless of what condition somebody in. But I know that whatever happened that night, it wasn't nothing intentional. It's just that it was a bad decision. Because I could be on the other end and be trying to understand why, but I can't ask myself why, but he has accepted that I did wrong, and I never should have, you know, I should have listened, because it goes from not listening. So, you know, that's all I want to say.
Do you know, Ms. Cobb, how any of the other young men are doing? I don't know if any of those kids, they were kids then, were closer to your son, and so you might have a connection through those families, so you could say, yes, one kid, there were no injuries, another kid, he lost his left leg, or...
Well, as far as who he was hanging with, these wasn't Preston's friends. It was just, hey, I think three of the other ones, they went to the same high school, and then, like I said, I don't know, Preston didn't know Darrell, but it's more like someone knew someone else. And
Right, Boss knew Darrell, and he brought Darrell along. And my question isn't who knows whom so much as if you are aware of how the other young men are doing. I know how Darrell is not doing, which is not well at all. And we heard a little bit about Boss Newton. There were some issues, but the prosecution team couldn't track down his family.
Right, as far as, I don't know their condition, because, you know, from the hospital, there was some, you know, situations where I had to, you know, step back
and, just for legal purposes, step back because it was more of other issues going on, then let's focus on what's at hand, our children's well-being. But, you know, I just know what injuries they sustained because my insurance, you know, had to deal with me and, you know, compensate Darrell and the other three. But far as how they are doing, it was just, you know, I need to step back and, you know, just like he couldn't have me contact, I needed to do the same.
Okay, got it. Well, I appreciate you being here for your son. It's a good sign for him. He's got family behind him. I know you're not the only one here for him. Thank you.
Thank you.
Ms. Rios, anyone else besides Mr. Cobb?
Do you want to speak? I'm sorry, I think his other grandmother, Ms. Jones wants to speak.
Good afternoon, Your Honor. State your first name. Joyce Jones.
Hello, Ms. Jones. Tell me your connection to Mr. Cobb. Your grandma. Okay, what do you want to share with me?
That Preston, unfortunately, just stay in tune with what has been said. Preston has never been a bad kid. He's always been a kid that pretty much listen to what we tell him to do. And, you know, it's just, when kids get together, they have a tendency to make bad decisions. And that was one of the ones he made. And it wasn't because he was trying to be ruthless or trying to be out of pocket. I'm not, my mind is running.
That's okay. I know what you're saying. This isn't a situation where he said, I'm going to get these guys and I'm going to drive a car into a tree. That doesn't make sense because, of course, he was in the car. And so he was just as at risk of going through the windshield and dying as anyone else.
And my heart do go out to the family tremendously. You know, we are very, very hurt that the family have to endure this. But, you know, it wasn't something that was set out for revenge or any type of malice whatsoever. And, you know, we just want them to understand that, you know, we don't want for their child to be suffering, just like we don't want our child to suffer as well. You know, and you know, even if he had to do community service some kind of way for that to attain that, we do mean well for their child, and we mean well for Preston as well. And you know, we just like for them to just take another breath and just say, hey, that was an intention.
I hear you. And it's not their job to forgive. They may get to that point, but that's not their role. Their role is to lift up their son, and they're trying to do that. And it is for them, I think, going to be a forever issue. It doesn't sound like, I'm not a doctor, but it doesn't sound like Darrell is going to suddenly wake up one day and be able to uncurl his hands and move his legs again. So I hope that the family is able to move forward, but I also hear you loud and clear that this isn't one of those cases where there is the bad guy who was out to get other people. That would be maybe if he pushed the car off a cliff with the other people in it, and he wasn't, and that wasn't this case. Okay, thank you for being here.
Thank you, sir.
Mr. Cobb, it is your turn if there's anything that you want to say, but like I said, you're not required to say anything at all.
I just want to say I'm fully sorry for what happened that day. And like I said, I didn't do it intentionally. I never told nobody they couldn't get out of the car or nothing. It was like we was all in the car. Everybody was jumping around. I guess we was just being lit at the time, and then everything happened. But ever since that day, like, you know, I distance myself from that type of people. You know, these was people that stayed in my neighborhood. We all clicked up, and I just wanted to fit in with them because what I thought was cool, what they was already doing, I thought it was cool. I started getting mixed up with it, but I tried my hardest to stay away from situations that I know will put me back in the place I'm in now.
Talk to me a little bit. I don't want you to tell me facts about it because it may be an open case, but it sounds like just a couple months ago, you got arrested for driving without a license.
No.
No?
No.
I see Mom, but I'm not asking you, I'm asking him.
But I was arrested for a 2023 case that I had completed. That was when I was in school. I was rearrested because I guess however they do the court system in Clay County, they didn't never clear it because the plan, what the judge told me was what the program, I do the program and they expunge it off my record, but I guess they didn't never finish doing it. So when I got in the car accident with my mother, when the lady was writing the police report, she got my license and seen that everything that I had already did my stuff for it, I still had an active warrant, so I had to redo the process and repay the money, but I got everything back and everything has been cleared.
Okay, so the arrest that we heard about from February of this year was sort of a rearrest for something that happened a long time ago.
Yeah, 2023, but I was not driving. Okay. I was not driving or nothing. It was just
in February of this year, you weren't driving.
Never driving.
It just was for something in 23.
Yes.
Okay, that fits a little more because Ms. Smith-Man mentioned something about 23. Do you have anything different on that?
I do see the arrest from this, I also do see a similar case from 2023.
Okay, all right. Anything else?
No shit.
Okay. Well, Mr. Cobb, I find that there is a factual basis for your plea. You were driving this car super fast, it hit a tree, and there were tragic consequences. We had a case like this that went to trial not too long ago, that even older than this, and it was even worse outcome. It was friends who were, what'd you say? We got lit, they were goofing around, cement wall, 2 of them died. And the issue was a little different because they couldn't quite tell who the driver was. The accident was so bad and bodies were everywhere. So the big debate was who was driving. Here we don't have that struggle, but it's the same situation where they're all friends. So it's not someone's out to get someone else. It's just this question of recklessness and what are the consequences for that. So I do find a factual basis. I also find that your plea is knowing and voluntary, meaning you've understood what we've talked about. You've told me you don't have any questions, and it's voluntary. No one's forcing you to enter this plea. Is that a fair statement?
Yes, sir.
So I'll accept your plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
And Ms. Smith? And Mr. Cobb, is it okay if we sign the indictment for you indicating your guilty plea?
Yes, sir.
You want to be sentenced as a first offender. You qualify for that. You don't have any felony convictions. This is on the more serious end of things to get first offender. But if you are sincere in your commitment to making better choices going forward, first offender protects you in the sense that there'll be a sentence and there'll be consequences for this. But unlike Mr. Wilson's situation, they won't be forever consequences because at the end of your sentence, if you did well, it can all be sealed up and you can try to move forward in life. First offender, that's the benefit, is that it can come off your record. The risk is that while you're under this sentence, if you mess up and get in new trouble for something, you'll have the new charges, but you also can have your first offender status taken away and you can be resentenced as if you pled guilty and we start all over again. So it could be a worse outcome than it is today. Do you understand how first offender works?
Yeah, I understand.
Do you want to be treated as a first offender?
Yes.
Okay, well, I'll do that. So I'm talking to you, Mr. Cobb, but I hope Mr. Wilson's family is listening, and I know your mom and your grandmother are listening. This isn't about who picked up whom. It really isn't. It doesn't matter who started out driving. It's about who was driving those seconds leading up to impact. And that was you. It wasn't anyone else. It wasn't Mr. Newton, clearly wasn't Mr. Wilson, or the 2 other guys in the car. And so you all may have been doing kind of the same kind of things, and it's kids goofing off, but it was goofing off as if you were playing with a loaded gun. When you're driving 100 miles an hour, you might as well have been throwing a loaded gun at each other, and you hope it doesn't go off because it hits the ground and someone gets shot. You are not a professional race car driver, and your ability, none of the guys in the car, to figure out what to do when there's a sudden turn or there's a tree in your way going 120 something bad's going to happen. And I don't believe for a moment that you had it out for anyone in that car, because the way to get at someone is not to drive a car you're in into a tree. It would be to do something to them when they're not in the car or hit them with the car. So I don't think this was, your grandmother used the word ruthless or malicious. I don't think you wanted anything bad to happen to anyone, including yourself. But what you did was so dangerous and so reckless. It clearly had consequences for you. You were injured, but just hearing about the consequences for Darrell Wilson, and I don't know how Boss Newton is doing. I don't even have names for the other guys. It's this kind of situation where there are repercussions for those other consequences. And while I appreciate that since that time, you've done pretty well. There was an arrest for battery against a pregnant female. I don't need to hear about it. It's just an arrest. But by and large, we certainly haven't repeated this. You didn't get arrested again for speeding in a crazy way somewhere or getting into a wreck. But we can't erase this. This doesn't go away. And part of what we do when judges are thinking about what's the right sentence, you want to rehabilitate, and you've brought in resources that are all about rehabilitation. But there is sometimes a punishment aspect to sentencing because what happened was wrong and it had real serious consequences. And I have to weigh that as well, and deterrence to make sure nothing like this ever happens again. I think what you went through and what you've learned, I'm gonna call them your friends for purposes of this case. You knew these guys. What they've gone through hopefully would deter you from doing this again. But there's the reality of what Ms. Thompson and Mr. Wilson are having to work through and support for the rest of Darrell's life. And when I weigh all that, Mr. Cobb, I think that the right sentence in this case is an overall sentence of 7 years to serve 2 years with a balance on probation. It is a custodial portion that reflects the seriousness of what happened and the tragedy of what happened and the fact that punishment flows from making those kinds of decisions. I understand the recommendation of 5 years, but I also very much understand dumb things that 18-year-olds do. I have an 18-year-old son, and he is smart, like you're smart, but he's also dumb because he's 18, and he will make bad decisions. And you made going that fast with all those people in the car, who knows who was wearing a seatbelt and who wasn't, a tragically bad decision. And it has cost Darrell Wilson his ability to move about in life like every young man would like. You've still got all those freedoms. And once you serve your time and you'll be paroled, you have no criminal history, you'll gain all those freedoms back in a way that Darrell won't. If you want to have a family, if you be able to care for your mother and your grandmother, have a career, be a senior executive at Amazon, not just a guy doing customer fulfillment. Those are all possibilities for you that were taken from Darrell because of the decision you made. So I'm just trying to explain to you the thinking behind what I'm doing. I am not deaf to the good things that people have said about you, and they're all true. You are more than what just happened today. And that's why you'll be able to be all those things when you're done with the custodial part of your sentence. You will then be on probation. It's a first offender sentence. The only special condition of probation that I'm imposing is that you need to have no contact with any of the people who are in the car or their families. So even though you may want to reach out to Mr. Wilson's family to say, hey, just want to see how Darrell's doing, that outreach would need to come from them. And if they want to check in, they could do that. But they're going to do their best to move forward, and you won't be a part of that. You have done well while you have been out on bond, and so I'm okay with a delayed reporting date. In other words, you don't have to go into custody right now. We'll give you an opportunity to talk with Ms. Rios about when you want to turn yourself in. It's here, you come back to court. It's not months from now. It would be in the next few weeks that you need to come back here. But I'm gonna let you and your family and Ms. Rios talk about that. And then you can let me know if you want to just get started today, or if you want to have a reporting date. But know this, in case you get any thoughts about, well, I could use the delay reporting date as a way to get somewhere else. If you're not here on the date and time we agree on, then I will follow the state's recommendation. And the sentence that I'm not actually signing any paperwork today. I sign the paperwork whenever you turn yourself in. So if you want to go in today, I'll sign it today. If we agree it's date X, then I'll sign that paperwork. But I'll actually have two different sentences. I'll have the 7 to do 2. I'll also have the 10 serve 5. And if you're not there on the day you're supposed to turn yourself in, I'll sign the 10 serve 5. You'll bot yourself 3 more years in prison. And eventually you're going to run a stop sign, you're going to get pulled over, and that warrant will be sitting there and you'll need to deal with that. So I encourage you to be here on the day you need to be here, assuming you want a delayed turn-in. Did you and Mr. Cobb talk about that at all, Ms. Rios?
Not a turn-in date, yes. We'll go outside.
Okay, please do. One last thing. I didn't impose as a special condition participating in any programming, only because I'd want to give Mr. Cobb the opportunity to think through what's the best fit when he gets out. And that's a great program and he'll still be of age to be in it. But that's a decision for family to make when he's finished up with the custodial portion. Okay. Before you go, do you have any questions about anything I've said about your sentence?
No, I understood everything you said.
Okay. Go chat with Ms. Rios and let me know. Is Mr. Clark in the courtroom? Hey, Mr. Clark, if you could come on up to the podium. So, Ms. Niles gave me a summary of what you're trying to do and the situation we bumped into. In order for me to authorize you to not have to pay the filing fees, I need something more than just your say-so. And it's not me doubting you. It's just we're required to have documentation that you qualify. It's an EBT card, or it's something from the Department of Labor saying Mr. Clark hasn't worked the last 2 quarters, or because they would have a record if you were working. It sounds like right now you don't have something that falls into any of those categories.
I just got the paper from True Light when they let me go when I got laid off. And
right, but the problem is, I don't know that since you got laid off by True Light, you didn't start working for Wells Fargo or for Amazon. And you're saying no, but I have to ultimately have documentation that we put in there, because Bill Gates could come in and say, I'm not working at Microsoft anymore. And he can't get one of these. He would need to document that he's been unemployed for a while. So you can get something from the Department of Labor. They are able to generate that because they have a record of earnings, and it would show for the last quarter you didn't earn anything. Some people use as a proxy, they have a EBT card, and you can't qualify for that unless you are struggling economically. But I don't have that kind of evidence from you, and that's what I would need to see in order for me to give this the green light.
so today is the 7th day of the the apartment is already paid in full. I'm just trying to make sure I don't get this on my eviction on myself. So how much time I got? Because I caught the train and the bus, and the day the 7th day.
So if the rent is paid in full, you owe $8,000 to the landlord. Why would they be evicting you?
Oh, they're not going to do it, but I'm trying to make sure no evictions on my record from here on out, because I just put the check in their hand the other day ago.
So you're good, but with you won't be evicted, you want to keep your record clear.
Yes, sir.
Got it. Fair question. I don't know that you need to appeal the ruling so much as you could get it set aside. But it's a good question. I haven't run into someone. Usually the scenario is, hey, I haven't paid, I'm hoping to pay, and I want to appeal because maybe that'll freeze it, which it won't, because as you've learned, you got to put money either in the registry or into the hand of your landlord. Of course, that begs the question of, if you just gave him $8,000,
I paid
No.
in full.
okay, you paid him full, you gave him $1 million. How is it that you're coming in here saying,
I don't, because I was told this is my first time, so I don't want no eviction put on me, like
I understand.
my record. When I move from there, I want to be able to get another place in my name.
right, because that little mark will follow you around.
All
Yep.
around.
So, if they don't evict you, if they don't get a writ of possession,
Yes, sir.
then they're not evicting you. That's what I can tell you. If you can get me some documentation, from the Department of Labor or something else, I don't mean to limit you to that. If there's some other way you can show me the piggy bank is empty,
Absolutely.
or I haven't been working, or I've got the EBT card. Those are the ways we go about it. The tricky part about the piggy bank is empty is you could say, look, there's nothing in my Chase account, but no one knows that in your Wachovia account, there's $100,000. Because I don't know all your bank accounts. That's why Department of Labor is pretty thorough, and then the EBT card. So
So I have to, today by being the 7th, I still have to have this done. This have to be done today. I have to.
if you think that you have to have a petition of review filed, then yep, I guess if this is the 7th day, but if it's paid in full and you aren't in fact going to be removed, they aren't going to get a writ of possession, then you may not have an issue anyway.
Okay. Then.
And that's a great question to ask folks at the, I don't know if you got help from the landlord tenant clinic, but there are people who could answer that for you that, hey, no harm, no foul, because they never got that writ of possession.
Okay.
Okay?
Gotcha.
I'm here tomorrow doing the same thing. If
Well,
you do, I understand that's day 8, I get the math, but you may still want to do something. And so if you get documentation, or you end up talking with someone who gives you a better sense of how this will all flow, don't be shy about coming back here, if you need to do that. Okay?
Okay.
All right. Ms. Rios and Mr. Cobb, if you all will come back up, please.
Your Honor, we would request a turn-in date of June 1st.
Okay. I can't say no to that because I just said yes to that. So we'll do June 1. That is 3 weeks and a few days from now. It's going to be a complicated few weeks for you, because you know what's coming, and it's not a happy thing that's coming. My counsel to you is make good choices between now and then. And most of all, be here, this courtroom, you've been here before, by 9 o'clock on June 1. I will be here. In fact, I'll probably be sitting right here because we're supposed to pick a jury that day.
You be here.
You need to be here. Don't bring lots of extra stuff, because whatever you're wearing, I don't know that you'll see again. So don't bring a nice watch or this or that. Just real basic clothes. But come here. Don't go to the jail. And then deputies will take you in and we'll go from there. Okay? You've got it tomorrow, and I don't want you to lose sight of that. You're going to do some time for this tragic outcome. But then you'll be done with that time, and you can move forward in a way, like I said, Mr. Wilson won't. And this isn't going to heal Mr. Wilson. And I don't expect his parents to say, great, we're all set now. But it helps everyone understand that what happened to him meant something. And that there are consequences for the person who brought it about, unintentionally, but who nonetheless brought it about. Okay?
I understand.
I will see you on what day?
June 1st.
June 1st, 9 a.m.
9
Feel free to be early. If you're going to be late, you need to be blowing up Ms. Rios's phone saying, I'm on my way. Look, here's my camera. I'm filming. I'm on I-20. And she'll let me know, and we'll be relaxed about it. But if it's 9:15 and there's no sign of you, then I sign the 10 Cert 5. Okay?
I understand.
All right. Reach out to Ms. Rios if something comes up between now and then.
I got you.
All right. Ms. Rios, anything else?
Your Honor, thank you.
It would be 7 to serve 2 on all 3 counts, and they'd all run concurrently. Ms. Smith, anything else in Mr. Cobb's case? Is the theft by receiving? It can't. Really? Must have been a cheap car.
No, you're correct. You're correct. You're correct.
No, it's more than $5,000. So it's, yeah, 7 to do 2 on all 3 counts. All right. Do you all have paperwork here? Okay, good. You're being helped. And you are here. You're welcome to be here for no reason at all, but I was just trying to figure out if there's something we could do to help. You're here for one of the cases?
Yeah.
Which case? Ah, all right. That may be a plea. We'll see. What, is she gonna talk to Dublette? Are you helping her through all this?
I'm sorry?
Are you helping her through all this?
Yes, that's why I'm still here.
Okay.
The thing is, we were just gonna bring Dublette out here.
Oh, is it Dublette they're bringing out?
I hope so.
Okay.
It is, but we need to like get that going.
You think Cotton is more certain than Dublette? Okay. Well, we got about 40 minutes. I hope neither of these is super complicated.
How much?
Oh, about 40 minutes, maybe a little bit more. Judge Ellerby is going to handle presiding from when I got to get out of here till 5. You don't have to go in. You'll be here. Ms. Niles will handle it, and just we'll bring paperwork to her. Or if something has to be in here, she's happy to come 2 doors down. Yeah, I gave him a box. I gave him a brand new box. No, but I just handed you a brand new box. I think you were messing with your phone and he was trying to get tissue, so he grabbed. You put it back in your drawer so they don't grab it. Do you need another box also?
I got it.
Okay. Got this. Need it back, right? Well, I have plenty of extra boxes. So. Yes, that's a good spot for it. Unless you're gonna cry, then you have it back with you.
Yeah, so when you told me.
It was going they were in the car.
This is what was touch.
He left. Why did he? He was angry, so he didn't have time.
Ms. Smith, are you ready?
I'm ready to go back.
Okay. Ms. Dublette, how are you?
I'm okay.
Okay. Are we going to do a plea today? Is that what you want to do? I don't want us to dive way into this if this isn't what you want to do. Because I want to lay it all out for you. Monday is trial. It's not going to be like, what do we do after this? If you are interested in working the case out by way of a plea, and my calendar says that Ms. Dublette has her final plea rights still. So 2 options. Option 1 is you try a plea. Ms. Rios will advocate for whatever sentence you 2 have talked about. Is it non-negotiated? So Ms. Rios will advocate for the sentence you 2 have talked about. I'll hear from the state. And I'm going to impose the sentence that I think is appropriate. It may be more than what Ms. Rios asked for. It may be more than what the state asked for. It may be exactly what Ms. Rios asked for. You'll have the ability to say, no, thank you, if it's more than what Ms. Rios asked for. And then on Monday, we'll do the trial. You also, if you know in your heart of hearts that you're not going to plead and you want the state to prove its case, then we don't have to do a plea today. We can just do the trial on Monday. What changes after today is if you get cold feet in the middle of the trial and say, I don't want to do this, I want to work it out, and you want to enter a plea, you can do that. You can enter a plea at any time. You could enter a plea while the jury is deliberating. You just don't get to withdraw your plea after today if you're unhappy with the sentence you get. Does that all make sense?
Yeah.
Tell me what doesn't make sense, because your mouth said yes and your head said no.
When you say I don't get to withdraw my plea, but I get to change my plea, what do you mean by that?
I wasn't clear. Today, if you say, let's try this, I want to enter a plea. If you don't like what I say in the end about your sentence, because it's different than what Ms. Rios said, you and Ms. Rios have a chance to talk about it. You can say, I don't like it, but it's better than what the state said, or it's better than going to trial, so I'll take it. But you also can say, nope, no thank you. And no questions asked. All right, we'll just do trial on Monday. You might decide tomorrow, if we don't do a plea today, you think about it, pray on it, however you process it. You know what? I don't want to go to trial. Ms. Rios, let's come in and do a plea. You can do that. And so Monday morning, instead of picking a jury, we do your plea.
Okay.
The difference on Monday morning is if I give you a sentence that you don't like, you don't get to say no thank you. Today is the last day you can back out of your plea if you don't like the sentence. After today, you can still plead, but you don't get to back out of the plea if you're unhappy with the sentence. That's the point I was trying to make.
Okay.
Same with like if you go to trial. If you go to trial and the jury says you're guilty, I'm gonna give you a sentence. You don't get to say, not that sentence, judge. I want a different one. You get the sentence that I give you. So after today, whatever sentence you get, trial or plea, is the sentence you receive. Today, you've got that ability to say no thanks. Do you want to go forward with a plea?
Yeah.
Okay. Ms. Smith is going to put you under oath, and I don't remember, did we get partway through a plea before, or?
No, we didn't even start.
Okay, so Ms. Smith is going to put you under oath. She's going to ask you questions about you, your case, your rights. You need to answer her questions truthfully, but you also need to let me or Ms. Rios know if the questions don't make sense, if you're confused by something. Will you do that?
Yes.
Okay, and make sure when you're answering, you speak up, outside voice. Ms. Rivers is close, but I'm having trouble hearing you, which means she's going to have trouble hearing you, okay?
Okay.
All right. When you're ready, Ms. Smith.
Ms. Dublette, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Desiree Lachey Dublette.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I'm under anxiety and depression medicine.
Do you take that in the morning or in the evening?
In the morning.
Did you get it this morning?
Yes.
When you take it, does it make you woozy or drowsy?
It makes me sleepy.
Sleepy. Are you sleepy right now?
A little.
Are you awake enough to understand what's going on?
Yes.
If you get too sleepy, will you tell me?
Yes.
Okay.
How old are you and how far have you gone in school?
I'm 27 and I got my high school diploma, and I was in college, but I didn't get to finish because I got incarcerated.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
Are you satisfied with her services?
Yeah.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Ms. Dublette, do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yeah.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, out loud.
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witness called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of each charge, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you understand that those are the rights you'll be waiving by entering this guilty plea?
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Ms. Dublette, has anyone forced, threatened, or promised you? Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 006979, how do you plead to count 1, aggravated assault, and count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Repeat that, please.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you. Your Honor, if this case were to proceed to trial, state would show that on September 22nd, 2025, officers of the Atlanta Police Department responded to a person shot at 244 Peter Street, Southwest Atlanta, Georgia, also in Fulton County. When the officers got there, they met with Terrence Barron, who's the victim in this case. They saw that Mr. Barron was suffering from a gunshot wound to his lower abdomen. Mr. Barron was found outside the location. For reference, the 244 Peter Street is like an apartment complex or condominiums. So Mr. Barron was outside of that location, leaning on a vehicle. At this time, the officers asked what had happened, and Mr. Barron told the officers that he had 2 females inside of his apartment that he got into a verbal altercation with that spilled out into the like patio or outside area of the apartment complex, where he was then shot by one of those females. The officers asked for a little bit more background, and he told the officers, the victim in this case, told the officers that he met with the 2 females earlier that day at a Mexican restaurant, and then they went to another location. They were buying drinks, they were eating before Mr. Barron invited the 2 women back to his apartment. When the 2 women got back to his apartment, there was an understanding that the victim states that they were to engage in intercourse. At that time, the intercourse did not happen. However, the victim states that the defendant in this case and the other person that came with her tried to take money from his pockets. At that time, the victim asked both ladies to leave his apartment, and that's when a verbal altercation occurred. During the verbal altercation, the victim states that the other person that was there with the defendant, and her name is Rashia Dixon. First name is spelled Raesha. Last name is Dixon. He states that Ms. Dixon took his gun and tried to leave the apartment. So once he followed them out of the apartment complex, complex requesting that he gets his gun back. Ms. Dixon threw his gun over a balcony, and simultaneously, this is when the defendant pulled out a gun and pointed it to the victim in this case. So the victim in this case then tried to, they got into a scuffle over the gun, and the defendant in this case shot, and one of those shots went into the victim. This was recorded on
You said the victim shot?
the defendant. Did I say victim? My apologies.
But Mr. Barron and Ms. Dublette were scuffling over a gun.
That's correct.
Based on what you've been told, there are two guns in the mix. One belongs to Mr. Barron and Ms. Dixon throws it somewhere. And Ms. Dublette pulls out a different gun.
Yes.
And is pointing it at Mr. Barron. Barron and Dublette, scuffle over the gun, wrestle over it. It goes off, and Mr. Barron is shot in the lower abdomen.
Yes, that's correct. So the gun goes off the first time, and that shot hits the victim in this case. Then the gun goes off again. When I spoke with the victim, he said he was shot twice. It's reported that he was, the facts that I have, that he was shot once, but the gun did go off 2 times in this case. At this time, the defendant and the other person that was there at the scene, Ms. Dixon, had left the scene. However, throughout the investigation with the officers here, they were able to do a photo lineup, and they were able to trace back the people who the victim was in contact with that day back to the defendant and her friend, Ms. Dixon. They both did interviews. Ms. Dixon stated that the same thing that the victim said. They met him at a Mexican restaurant with the intentions on going back and engaging together. However, that turned sour when he started to accuse them of taking money from him. He told them to leave, and this verbal altercation happened, and the defendant in this case ended up shooting the victim. I would like to share for the court the victim that the state, the video that the state obtained that we have shared with defense in this case, showing the shooting. So I'll be sharing my screen.
Oh, okay.
I know you stated earlier that I could share it, but it does have some nudity. Is that okay, right? Okay.
It's what you would have used at trial.
Okay.
He said he's not waiting around for it because I said we're going to lunch break and you can't do it until after. So I said, I don't have time to leave on this. I have to do whatever. He said he has to work or whatever, and got upset. I mean, he's been cussing me out since I first got here, just really mad. Just seems angry. He's in this whole situation, makes everything. I get it, but it's not the same video that Josh showed me. That is what I showed you. I watched that video. That's what I told you. You've seen this video. He had on a shirt. No, he was always naked. I saw the video. The one I showed you in the back. You saw the one the one I showed you in the back was this video. I showed you this video. That's what I seen. That's what we saw in the back. The one you actually showed me. Sure.
At this time, the defendant and the friend that was there with her, Ms. Dixon, left the location. But as I stated earlier, warrants were taken out for the defendant in this case, where she was arrested for the charges we have that's before us. Regarding the recommendation from the state in this case, the state is asking for, on count 1, 3 years to serve, and count 2, 5 years on probation to run consecutive, for a total of 8 years to serve 3, with the balance probated. Regarding the special conditions in this case, the state is asking for the defendant to stay away from the victim, of course, no contact with the victim, to stay away from the incident location, to complete an anger management course, to also complete an alcohol and drug evaluation. That comes from the stance that they were all out drinking previously. And the voluntary intoxication may have played a part in the decision to shoot the defendant, the victim in this case. And also the state is requesting restitution, but we'll do a restitution here because I did speak with the victim, and we have to get those medical records from him. I did get a chance to speak with the victim in this case. He was supposed to be on the Zoom. I think he's working, so he's in and out, but he did let me know that if he's not on the Zoom, that he would want me to make a statement on his behalf. So I'd first like to check to see if he's on the Zoom.
So there's Jada's iPhone. That's it from the outside. That's been on.
Cotton.
Pardon me?
That's for Mr. Cotton.
Okay.
Okay.
Poor Jada's iPhone's been on for a long time.
So since he's not on the Zoom, Your Honor, he wanted me to share that this incident has changed his life completely. He states that he was shot twice. He was treated for those gunshot wounds. He's going to physical therapy. He's able to, like, it seems normal for him. He's still able to go back to work now, but things are harder, things are slower for him. He does want the defendant to be held accountable for what happened in this case. He did state that he believes that the state's offer is a little bit too low and that he would like to see more time. We kind of talked about the case as a whole and what the state would be able to present if this case goes to trial and why we were offering the 8-serve-3. However, nonetheless, he did understand the state's offer in this case. But ultimately, he just wants the court to know that everything has changed for him and he wants the defendant to be held accountable. And that is all from the state, Your Honor.
Okay, thank you. Ms. Smith-Mann, do you have any criminal history information on Ms. Dublette?
Yes, Your Honor. There are 18 cycles, a 2019 charge, nolo contendere, and a notable charge. There is a 2021 theft by deception conviction. It was 12 months for that. Probation. There is a that may be all, but I had one more page I wanted to look at, Your Honor, if you just don't mind.
Okay, while you're checking.
That
Go ahead.
concludes everything, Your Honor.
Okay, thank you. Ms.
You're
Simpson, do you have Ms. Dublette as ever having been on felony probation?
Felony probation, I have been with hearing judge, and she does have a probation warrant with this case being the basis of that warrant.
Okay, and what's she on probation for?
The charge is possession of methamphetamine. She took that plea June of last year. And it's a conditional discharge sentence.
Oh, okay. All right. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Dublette is 27 years old. Mr. Dublette, I'm sorry, is 27 years old. She's from Georgia. She has two kids, ages 4 and 5. One of her children is autistic and special needs, and she needs to be out so she can care for him. Her dad is caring for her children right now, but he is unable to, he's struggling with work and just not able to care for both her children. And so that's why she needs to be out so she can take care of her, especially with her son with special needs, but both her children. They were here in court, her father and her children at the last court date and this court date. He couldn't stay because he needed to go to work, but they have been in here in support of her in this situation. She was doing well besides this case. She was working in Cookout in Tucker. She was living with her father. Now, in regards to the facts of this case, from the video, he was moving towards her. And I think in this moment, she believed that she had been drugged. She wasn't sure what happened to her. And I know the video does show her with the gun, but he is moving towards her and she's in a defense stand and he's trying to tussle with her in the gun. And I believe she would have thought if he took the gun, he could have shot her. She has not a lot of memory because she believes she was drugged and she is a little hazy. But even just based on the video, he is moving towards her. She didn't know what was going on with the other guy, if he had the gun or not. She didn't see.
You say the other guy.
The other girl, I'm
Okay.
sorry, Miss Dixon, who later you could hear her say, I threw the gun over, I threw the gun over. So she didn't know who had the other gun. So in that moment, she was scared. She didn't know him very well. She just met him that day, was back at his house. So I think it was so much going on in that situation. I don't believe she intended to shoot anyone. I think she was scared and trying to defend herself in that moment. She does not have a violent history. Most of her history, I believe, is drug related, and had some issues with that. But she's a good person. She's been a good mom to her kids, and she's just concerned about the welfare of her children if she stays in jail or has to go to prison because her kids are so young at this point. And I believe she can't, they're 4 and 5, and I believe she can't even enroll them in school because she would have to give up parental rights to her dad, which she doesn't want to do at this point. She wants to be out to take care of them.
I would have no choice to do with me being in here.
If she's in, she's saying she would have no choice. I'm asking for 9 serve 7. She's been for 7 months already. And for the remainder to be on probation.
9 years to serve 7 months?
Yeah, so count 1, 5 serve 7 months for the breakdown, and then count.
Followed by,
Well, I guess.
it'd be 4 serve 7 months.
And then,
Yeah.
yes,
Okay.
and the count 1, 5,
All
count
right.
5, consecutive. I think that was the only thing.
I've been taking AA meetings too before I got incarcerated because of my probation. I've been taking AA meetings and NA classes.
She has been trying to address her substance abuse and drug problems. She had been taking AA classes and substance abuse. That's separate from, I don't want to confuse that. She believes she was drugged in this situation, but that's separate from her personal drug issues that she's had.
Okay. Ms. Dublette, anything you want to add?
No, sir.
No?
I do want to apologize to the victim though, because I didn't intend to shoot him. If I would have been alerted and remembered anything that happened that day, it probably would have never ended in him getting shot. The situation would have been a lot differently. But if he was here, I would personally apologize to him myself.
Okay, I appreciate that. Could you show the video again? Please? I'm sorry to make you watch. You don't have to watch it again. It was hard to follow who was doing what to whom. You can see the gun go off once, but it's almost like it would have hit poor Ms. Dixon. That's what it seemed like the first shot I saw. So can you pause it for a second? All right, so Ms. Dublette is the person in the blue and white dress, and Ms. Dixon is in all black.
That's correct.
And the naked guy is Mr. Barron?
Yes.
Okay.
When I first time again.
Okay, thank you. Ms. Dublette, I do find a factual basis for your plea. Mr. Barron got shot. It was your gun. You were holding it. I also find that your plea was knowing and voluntary, meaning you've understood what we've been talking about. And when you didn't, you asked Ms. Rios. I saw you guys have a few sidebars. And no one's forcing you to enter this plea. You decided you want to go forward with the plea. Is that correct?
Yes.
Okay, then I'll accept it. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
And Ms. Smith for you?
Yes, Judge.
And Ms. Dublette, can I get someone in my office to sign the indictment for you?
Yes.
It just means we're putting your name on there indicating your guilty plea. We don't tend to pass papers around as much as we used to. Is that all right if we do that? Yes? Okay. All right. Ms. Dublette, based on the evidence I've heard and the video I was able to watch, I do see Ms. Rios's point that you were sort of backing up and Mr. Barron was coming towards you in sort of an alarming setting. Not quite sure why you pulled out a gun. I think, made things more complicated and creates some criminal liability for you. What I'm going to do, Ms. Dublette, is sentence you on count 1 to 3 years to serve 1 year with the balance probated. And count 2 has to be 5 years and consecutive. I'll probate that. So it's a total sentence of 8 years to serve 1 year with the balance probated. The main condition of your sentence is to forever stay away from Mr. Barron and that address. So no contact with Mr. Barron, can't be back at 244 Peters Street. I think he's pretty much a stranger to you, so that shouldn't be difficult.
I was gonna say that.
But don't make him not a stranger. So he gets to go about his business. You will need to take an anger management course. You'll need to submit to a drug and alcohol abuse evaluation. And if they recommend any treatment, AA classes or sessions or anything like that, that treatment will be part of your probation. It'll also be a condition of your probation that you take any medication that doctors have prescribed. So if a doctor prescribes the kinds of things you told me you're taking, you got to take that. That's not optional. And you will have a probation officer who's going to make sure you're current on your meds. All right? You'll get credit for the time that you've been in. That's a different sentence than what your lawyer asked for. So I'm going to ask you, first, do you have any questions about the sentence that I just described?
You said a year, 8 years to a year, so that means I'm only doing a year.
Right. You will serve a year. You'll get credit for the time you served, and then you'll be on probation for 7 years.
So that means I'm only doing 5 months.
Whatever the math is, that's the most you do. You are eligible for parole, so you might do less than that. But the most you'll do is a total of a year from the time you've been arrested in this case till you be released. You are legally entitled, and I'm making clear that you get it, credit for all the time that you've been in.
Do you do 2 for 1?
I don't do 2 for 1.
Oh.
Okay? Talk with Ms. Rios and let me know what you want to do, okay?
Okay.
While you're having that conversation, Ms. Duff. Hey, how are you? So Ms. Duff, I'm sorry you've had to sit here so long. Your daughter has been super quiet and is well behaved. The judge who entered the final order in your case made clear, and she's legally correct, that there's no direct appeal in your situation, which is what this petition would be. So I don't want to spin your wheels for you. You qualify for the affidavit financially, but I'm also supposed to screen for legal questions. And when someone defaults in magistrate court in this setting, there's not a direct appeal. And Judge Oliver put it there. I know you read it, but why not try? You should try. But one of my screens is to make sure you're not a millionaire, because then you need to pay the fees. You're not a millionaire. But I also need to be comfortable that there's a legal basis for what you're trying to do. And you may have all sorts of good arguments against Leland Point, but the reality of a default is that you cannot legally appeal from it. So I'm going to actually sign this order, but it is not approving the affidavit on that legal basis. It's not a comment on your financial qualifications. It's what we call a non-justiciable issue, because you can't appeal a default judgment in an eviction situation. Okay? Not the answer you wanted, I know, but I don't want you to be wasting your time and you file it. And then all that judge who gets it is going to do is say, dismissed, and then you've been heading in the wrong direction. Okay? I hope things go as well as they can for you. I know you're in a bind.
Yeah, Mara, that's how I was trying to do it.
Got it. Well, hopefully you have a place to land. You got a beautiful little kid. Let me get this paperwork back to you. We are running out of time to do Cotton. Is it a complicated one?
I don't think so. It's a reduction, but just like a normal plea.
Pardon me?
It'll just be like a normal plea, but you have to just speaking for him, so then.
Yeah. If Mr. Cotton needs to come back tomorrow to do his plea, are you able to appear on Zoom? I don't know if you were going to speak on his behalf. You were going to speak, maybe you're on the victim side. Okay. All right. But you're here for Mr. Cotton.
I'm sitting in here.
Okay.
Yeah.
Got it. You're not the victim in the case. Okay. You're just hanging out. Okay. You're welcome to hang. We may have to do his plea tomorrow. And you're welcome to sit in here tomorrow too, but you don't have to. Okay.
Judge, she wants to accept the plea, but I do have a question. I thought she used her first offender on the drug case, but if that was conditional discharge, she should have a regular first offender available. Can she use it?
She should have it available. Are you pretty sure it's conditional discharge? I'm not doubting you. I just don't know.
I'm looking at the actual disposition. It's
Okay.
conditional discharge since.
Okay.
it's The only case that she has.
Got it. Yes. Do you know how conditional discharge works?
No, sir,
Do you know how first offender works?
not really.
So why do you want it if you don't know how it works?
Can you explain it to me, please?
Yes. I'm just curious why you want it, not knowing how it works. You have to pay $100,000. First,
$100,000. Oh.
first offender, which is a little complicated in your case because you have this other case, but set aside this drug case where you're using a different approach. If you haven't been convicted of a felony before, and you have not, because with your Henry County case, you're doing this conditional discharge, which is a lot like first offender, you can be sentenced as a first offender. It's still a sentence. You're not going to get any less time. It's not going to be 2 for 1. It's not going to be shorter probation, but it's also not a conviction. So that should you try to go back to school, you mentioned you were in college for a while. If they say, are you a convicted felon? The answer is no, I'm not. You can have your record restricted so people can't see that that's in there. And it's helpful with employment, school, et cetera. That's the benefit of first offender. If you are working through addiction and mental health challenges and you're not sure you're going to stay out of trouble over the many years you're going to be on probation, it's a risk. Because let's fast forward 18 months and you stop taking your medication, things are stressful, you have too much to drink, and you take some guy's wallet or you get in a fight or whatever it is. Heaven forbid you have a gun, because you cannot have a gun as a first offender. But you get caught with a gun and you get new charges. Not only do you have to deal with your new bad news, but you'd come back here and the state, I am quite confident, would say, take away her first offender. And if I do that, I actually resentence you. And I resentence you with the full range here, which is 25 years. And I'd be looking at, well, what'd you do since you said, no, I'm actually a good kid. I'm not going to do something like this again. Give me first offender. And if you did anything where you're mixed up with guns and drugs, then it'll be a pretty big hit. It would be, I resentence you, and it would be some years that you'd go into custody. So there's a risk to first offender. If you're pretty sure I'm going to get in trouble again, it's all good. But because life is complicated, you have some mental health issues you struggle with and some addiction issues you struggle with, first offender can be risky. But you have a better sense of that than I do. Do you feel like you now understand what first offender is?
Yes.
Do you want to be sentenced as a first offender?
Yes.
Okay. I'll do that. Again, it doesn't change your sentence. It changes your future. It will make it easier to move forward in a productive way, assuming you're ready to do that. This will show up differently on your record as a first offender sentence. Okay? All right. Ms. Smith, anything else in the Dublette case?
Nothing further, thank you.
Ms. Rios?
No, Your Honor, thank you.
Okay. Ms. Dublette, when you are released, you'll need to report to probation within 48 hours. What's your best bet as to where you'll be living when you get out?
I'll be staying with my father.
And he lives in what county?
He stays in Fulton County.
Okay, then you'll get instructions before you're released, but you'll report to the Fulton County Probation Office, which is just down the street.
That's why I was reporting for the Henry County probation.
Good, same thing.
I got transferred out here because I stay out here.
Good. Well, that's where this will be as well, but you gotta report. You only have one officer, but you still need to report within 48 hours of your release, okay?
Okay.
All right. That's it.
Thank you.
Ms. Rios, I chatted with these observers here, who are observing in the Cotton case. I don't think we can fit that in today. But I gotta go. And so we can bring him back tomorrow.
Oh, you're gonna be here, do you want me to take? Goodness, I'll talk to him today and I can take it tomorrow. Cause she's not coming tomorrow. I was trying.
Oh, that's right. We had moved stuff. So, yeah. So, I have like 10 minutes. That's not enough to take the plea, but it's a chance for Ms. Wood and you to talk with Mr. Cotton to see if he's okay with Ms. Wood handling. So it's all your final pleas tomorrow? What's the plea? So Ms. Nelson, can you get Mr. Cotton brought over tomorrow, please? Oh, she sent something here. Nope.
Yes, I will do that, Judge.
Thank you. All right. Great.
Okay, excellent. I'll come on Zoom and if he needs to, she'll be here in person in case.
Okay. I don't want to intrude on what you were going to do tomorrow. So,
I was working.
okay. Work is good. I still haven't heard from Judge Polk either. So we may have nothing next week, but I guess you should just, until you get an email from me, be thinking about the 5 defendant one.
Sounds good, Judge. Thank you.
Yep. Will you get someone covering for you tomorrow or are you going to be here tomorrow? That's how you'd be prepping. Okay. All right. What are you guys here for? Oh, I was told you didn't need them right away. Okay. These are the DA ones, not the South Fulton ones? Well, it's not, because I got a folder here that is Lieutenant Moss.
Yes, sir, both are South.
The DA office ones are they both yours? You've got the other ones? Yeah. All right, let me go get those.
Yeah, they were there for the Thomas. They was trying to watch cop.
Oh, they were here for Thomas. Oh, okay. They're welcome to be here. They were kind of like, maybe I'm not here for Cotton. Got it. They were here for the bond hearing and everything. I don't remember them. Okay.
Can I ask what time tomorrow for Cotton?
We will do it first thing. Are you Jada's iPhone?
Yeah, I'm his wife.
Okay. What's easiest for you since you've been on all day? If we do it the first thing in the morning?
Yeah, that's fine.
So, you just need to get the Zoom link from,
Rios.
yeah, Ms. Rios will get it to you. She's gonna be on the Zoom too. It sounds like, and we'll just do it first off, okay?
Okay, thank you.
You bet. Let me go get these other ones.
Believe I don't. That didn't work if they work with it. Oh, I think you just told me those people are like.
No.
Where?
They cough and that's coughing.
The people that were still sitting here?
Yeah.
Cobb? Preston Cobb?
Not cough,
The Cotton.
Thomas.
How many?
So I guess he could.
Why did she say that? Because he asked the wrong time. Ask who they were here for.
No, I'm not.
But that's not what she said.
You know what? She said that, she said a cotton, but I think it's a library. A library.
I'm going to.
That's what they're. They wanted to know they had.
Aaliyah, did you? Are you right? I just took from the program. The honesty of the McBurney show is like off the tracks, but I know that she wants to. My concern is.
I'm gonna take that one memo down. Somebody should be coming up for that female.
So you think you probably not?
Yeah, you'll be good to go.
Yeah, but it's like you see to robbery. But probably no.
Come on,
Yeah. I mean, no, I don't. Exactly. Yeah. That's why I was like, he's a kid though. Are you weird, right? Yeah, weird. So she's got 4. He did. I think, no.
So
No, he didn't do that. No. I'm so sorry.
If he would have her again, I don't even think this would have been like a case. I think the case would be the kid.
No, absolutely, that's what we're talking about. Right, I was like, you might as well just go ahead and do file. Yeah. No, but for real, it's so great. Entitlement. No, I can't get my school to this, so.
Versions of the story.
Yeah. No, I'm like, oh, yeah.
Yeah.
Are you gonna be going with Judge?
No, that's my bad shit.
They never got, they didn't even do this, they were just going for something going on.
Well, no, she like was acting weird.
No,
She
I
was like, oh, not like saying she wanted to stop at different places, not actually go
I
to
have
the bank.
heard
So
so.
they got them or acting weird. So they got for the car. It's so many different stories. One is another thing.
They're saying the same, I'm saying different.
Different, like the sequence of events. They didn't do it.
You gotta look over them and say, they can all make some upgrade. It's still. But that's the one.
And a robbery.
Yes, a robbery. Sorry, the one
Oh, my God. Yeah, he does. He does.
Oh, you fired. And then it was. Yeah, 2 years later, to make sure.
Oh, it was a hijack. I didn't know about it. It was a hijack.
And that's why some things. I never knew how that worked.
That's what it was in there. Huh? It was a hijacking charge. That's what it was.
Oh.
And he had a robbery by force before that.
Yeah, I mean, he don't take the plea, but the girl was shady. She was 20. I mean, she was, the victim was like, but I said it out of the drop. I know. Yeah, I haven't seen him say out. For sure.
Well, he said they know, apparently, actually all said, they're not actually all said, but they didn't know he had a gun. I don't think they knew he had a gun. That he pulled out the gun out of nowhere. And so then, I think they were. They don't say
Which one?
Yeah.
Oh, the.
No, it's a life to it. Yeah.
You actually breathe over there.
And actually, see, no, I know, it's great, like actually in the victim, they were trying to stick together.
Yeah. She got one. That's good. Keeps changing. No, the story kept, I was like trying to make the timeline. Listen, I know what's going on. Like I said, I still think this is all the same ones. I know. Absolutely. I think it could go either way. So no. Well, it's because it had sound, so the sound is like, you can hear, you heard open gunshot. Okay. Yeah. I mean, really. What is it? Oh, and it was clear that she shot him, but Michael was like, she ran at her. And I think the problem was that she couldn't get home. She's black children. She ran at him. No. That's when I heard, I was like, yeah, that was in my pouch, because I thought it was emotion. So when I was about to stop, I got it. And then, I turned it on, so it was getting, and then I saw what it was getting, and I was like, what deal? But then when he said that street, I know, but, I think it was, yeah, that's a good.
Yeah, that's
Yeah, and that's how we got it. Yeah, well, yeah. Here, but, well,
Mr. Ryan?
okay. Cause I was gonna ask you, because like, I've been saying that since. Just how she. She was very. Not stuff, she said it's not that simple. Then after she. Yes, I do remember that. Yeah. And then she said to accept her property, she made one of her, she asked, you know, which one? Yeah, she was like, oh, and it was his test. Okay. No, we're not surprised, but she had. I got to see God, is it you? I have a question. She was one of. It's because she did, yeah, it's because she was saying more to separate her stuff like that. So what happened? They are trying to take. But once they